Hi, so I'm Professor Zubair Jahangir. I'm a company secretary and an advocate, and I've written a book on your labor laws. Not only these labor laws, but even the previous labor laws which were there. There were around 29 labor laws. So I have been teaching it for over 12 years, and I had written books on the previous one, and this time is the first lecture where I will be taking all the four new labor codes. They have a weightage of around 40 marks in your CS Executive Group 1 SBILL, 100 marks weightage in your CS Professional Open Book exam. So, and in LLB also you have labor laws and any other, even CMA, CA, etc. So can they also refer it? Answer is absolutely yes. I have made it from the core law, and I will be covering, and my entire notes covers the entire labor laws. It is impossible that anything comes outside of these notes. The reason is very simple. I have not left anything. So referring to these notes are going to be sufficient, and it covers the full Bare Act, including your module as well. Okay. Now, before I start, let me tell you how you can go ahead. So it will be a fast-paced revision of the labor laws. If you want detailed lectures where all the topics, all the sections are covered in depth, then I have given you all the Dream Batch. It's an access to all the paid lectures at a nominal price. Okay, and the links for those are also given in the description of the video. Now, before I start, let me tell you how you can get these notes. Either you join the WhatsApp groups, but in case you're watching this video later, then what you can do is simply you can go to our website, and in our website you will be able to see it's put up in the free resources section. So let me show you how. You'll go to our website, and in our website, if you see, there is this free resources section. Okay, in free resources, all our free notes, which are all very valuable, are given to the students. You go to CS Executive, and here I have just put out the labor laws notes. You see, thousands of students have downloaded all our notes. For labor laws, I have just put it out, so you all can go and download these labor laws notes. It is a one-click download. So you just go here, I click, that's it, and you see the notes. The beautiful notes will be unlocked. See these notes, okay? And you will see the full paper, full 100% of your labor laws with respect to the codes will be covered in this. So your codes that we will be covering is your code of wages, code of social security, your code with respect to occupational safety and health code, working conditions code, and the industrial relation code. Okay, and these are all the full. You will see, even if you are doing your LLB, this will be covered and extremely useful because the full Bare Act is covered. Now, with respect to CS Executive students, it is covered from a chapter number 16 to chapter number 19. Okay, the first code that is given is your occupational safety health working condition code 2020, then your industrial relation, social security, all of 2020. Only wages code, which was notified the earliest or the initially, is of 2019. So simple. And let's say if you are a professional student also, so very simple, you all can also take this notes in your open book exam. All you have to go is go to our website, free resources section, go to professional, and there you go further. You can also see the labor laws notes, and the same thing, one click download. Okay, so I would advise you all to go and get it printed, and the entire thing will be covered for you. Okay, now we will be starting with the code in depth. I want you, and what I will be covering is exam oriented topics which are important from exam point of view. That's all. Okay, now before I start, I would request you all that this, share the video links among your study groups, among your friends as well, and do like the video as well, and do let me know in the comment section how the video has helped you, or how you found it useful. So I'll feel really good. Now the next thing is this lectures will be 100% in English, so that students from all over India, including our lovely South India students, will be able to watch and learn. Okay, now without further ado, let's start with the session. So can I have in the chat box excited? I get excited in the chat box. So I know that you all are excited because the mind is more important than anything else. Once you put in positivity that in the next 3 hours, 3.5 hours, I plan to cover this entire code. Okay, let's begin. Great, great. Let's start. Great. Archie, you're excited. Let's see. So let's begin. Hi. So we'll be starting with the 4 labor codes. And in the 4 labor codes, the first labor code that we will be covering is your Occupational Safety, Health and Working Conditions Code 2020. Now, before we start any labor code in writing in your examination, because it's obvious that it's going to come in examination. So whenever you start your particular labor codes, it's important to write the introduction because that is how your answer will be started. So this I can say by default you will be writing in the examination. So what you will say that this particular code, the short form of this code is called as Occupational Safety, Health and Working Condition Code 2020. Okay. This code was brought in for the purpose. Now see the name itself. The object of this code is to provide safety, health, ensure the proper healthy environment and proper working conditions for all persons employed in an establishment. This is the object. This is what how you will start. Second thing you will tell that these labor codes, they have come after the recommendation of the National Commission on Labor. So you will write this that this code was based on the recommendation from the second law commission, National Commission on Labor. Okay, then we see that what this labor code consists. Prior to the labor codes, there were multiple labor laws. You will write a background. This is called as a legislative background. Whenever we write answers in law, we don't directly get it to the point. We first write the legislative history, and this is a part of the legislative history that you should write. That earlier, before the 4 labor codes, there were 29 central labor laws. How many labor laws were there? 29. All these 29 labor laws were there. They have been clubbed into 4 labor codes, and all those acts which were related are put together. So with all those acts with respect to wages were put on the code of wages. All those with respect to industrial relations, disputes, etc. were put under industrial relations. Then came social security, and then came with this part. Clear? So this will be your start, which mandatorily you will write in your examination. Okay, so 29 labor laws clubbed into 1, 2, 3 and 4. Concept clear? Now let's see this code with respect to the code that we are going to do right now. The first code that we are doing is a occupational safety, health and working condition code 2020. In this code also, what did it do? They clubbed 13 labor laws. So it consolidates 13 previous labor laws. Factories Act, acts with respect to mines, with respect to contract labor. These were all separate acts which have been clubbed into this code. Okay, and it received the President's assent on 20th September 2020 and was published on the very next day, that is 29th September 2020. So writing this kind of introduction is very easy to write it, memorize it, and it creates a very massive impact on the examiner. Now, what was the purpose of passing these 4 codes is very simple. 29 labor laws mean 29 registrations. 29 return filings, 29 compliance under labor different laws. So clubbing it made the compliance way easier, where one registration was sufficient for all the codes with respect to wages. So that was one of the primary objectives of bringing the 4 labor codes. Now still you will not start any answer, you will write the object of the code. Any law has a particular objective, why this code has been passed. So the code has been passed to consolidate and amend the laws relating to occupational safety, health and working conditions of the people employed. This is very important, is very important, has to be written in your examination. What is the, and this is given in the act itself, in the entire code itself. You open, they have started with the preamble. The objective of this code, the objective of this code is to club means to consolidate all the various laws relating to occupational safety, health and working conditions. Clear till here? Yes. Now we will start with the code. Now remember, I told you that the act has subsumed multiple labor laws. How many labor laws I told you I was clubbed for this code? 13. So 13 labor codes, labor laws were there. We will see which are these 13 laws which have been clubbed to make this particular occupational safety and health working conditions. So these were the acts which have been subsumed. Can you see these? These were the acts. So the most primary and the most important acts merged into this code was the Factories Act, Contract Labor Act, Interstate Migrant Workers. Interstate means what? If you know that migrant workers migrate from one state to another for the search of employment. So when they come from other states to work here into building construction lines, etc., they come. So for that, they were separate acts. These have been clubbed. The most important is Factories Act, Contract Act, Interstate Act, and then the other things also. You will see the other laws also which have been there. Building Workers Act, then your Mines Act, the transport, motor transport workers, and there was an act applicable to journalists. So even those have been clubbed into this particular code. Concept clear? So you will see not only about health working, but also you will see with respect to mines, you will see about construction workers, you will see concept with respect to motor transport workers and your journalists. Concept clear? So these were among the major 13 labor laws which have been clubbed into your Occupational Safety Working Condition Code 2020. Concept perfectly clear? Yes. Now what does this code contain, sir? Can you tell us what is this code? Now in the very beginning I have told you that nothing will come outside than what I am telling you. Sir, how is it possible? It's very possible because I have brought down the entire code here, the entire act. That means in this act, how many total sections are there? How many you can see here? 143 sections only. So so obviously if I tell you section number 1 to section number 143, any question or any topic with respect to this code will be asked from here only. Common sense on based on this only. So here we will see that they have multiple chapters. Similar topics have been clubbed into chapters with respect to this code. How many total chapters can you see in this act? How many are these? 14 chapters and total of 143 sections. You think all the chapters will be important? From exam point of view and from your main core law, what is important? If you see the name only, what is the name of the act? Occupational Safety, Health, Working Condition. From all of this, can you tell me which is the most important chapter and sections? Which is the most important chapter? Obviously, when you see here, chapter 4 to chapter welfare, right? All of this is where the main heart of the law is covered. And I expect the questions to come from here. In addition to that, there are some points which are also important, which is the next chapter also, your annual leaves. That is it. So I expect questions majorly from section, mainly it starts from section 18, 16 and 17 is very basic. 18, section 18 to section number 32 is the most important of the heart of the chapter. Which sections? Section 18 to 32 contains the heart of the chapter. Let's see what all is the code covering. The code other than that is covering about duties of the employer and employee. What is the duty of the employer to give proper working condition, proper safety equipments, proper accident reporting. Those are the duties of the employees to wear the safety equipments, etc. Then they go on to tell you have to maintain proper registers, and these chapters, can you see chapters such as inspector, offenses, penalties? Okay, these chapters are common in all the four codes. All the four codes will have the same content, almost the same content. 99% of the content will be the same for chapters such as inspector, offenses, penalties, okay, and maybe a social security fund. Concept clear? Think, just because I have written a book and the law has passed a law with respect to these codes, you think everybody is going to follow? No, you require authorities who will ensure the proper implementation of this law. So you have inspectors like your administrators who will be able to send a summons notice, who will be able to inspect the factories, who will be able to enter inside, take examination, and if you are unhappy, their appeal provisions will be given. Okay, if you are found guilty, then what you can do, etc. So these are there. And one small little point also they've given you with respect to special provisions made for employment of women. So this also I can say is somewhat important. So these are your importance which is there from year till year. Okay, and maybe this, and offenses and penalties etc are all repetitive in all the four codes. Clear till here? So can we begin? Yes. So now we will start the labor codes. The first thing in every single act, the very first section, section number 1, talks about the name of the act. Here also the name of the act is Occupational Safety Health Working Condition Code 2020. It extends to the whole of India. Definitions are always covered under your section number 2 in all your 4 labor codes. So the important definitions which as and when we are doing it, we will cover it. Now, directly when we see your chapter with respect to your duties, okay, duties of employer and duties of employee. Clear till here? So if I ask you normally when we start with the chapter that what do you think is the duty of an employer, which section it covers, it's not important, but we'll just take a highlight of it and move ahead. Duties of an employer. I'm just thinking that if any employer is there for any factory, he should ensure that there is proper, the name of the chapter, there is proper occupational safety, health and working conditions. Yes or no? Chapter only will write na that the employer must ensure that there is a proper safety, health and working environment. One. Second, in addition to that, he should ensure that the workplace is free from hazards. Okay, he should have a free annual examination and proper disposal of hazardous waste. So some point just to understand, not important, but this is what it covers. It also puts a responsibility on the employer that if in the particular factory or in his workplace there is any incident such as death or injury, don't you think it is important to inform the government? So then accidents must also be reported, okay, and any injury must be reported for to the officers. Clear? Then we see what is the duties of the employees. Normally what could be the duty of an employee? So I would say that the duty of the employee is to adhere to the safety standards provided, cooperative with, so he should comply with the safety standards, take reasonable care for his own safety. Because how much you think responsibility will put on the employees? Simply telling the basic, take care of yourself, and if there is any imminent danger that you have identified in the factory, do reporting of that. Inform. So cooperate with the workers, report unsafe work conditions, and not misuse any safety appliances. Clear till here? Section 14 talks about reporting of employee must report any imminent danger, okay, and who he will report to. In this entire chapter we saw that only one person, that is the inspector who is appointed for that particular area, you can report it to him that maybe I feel that this factory might fall down, this leak can be done, this equipment is not given. So those imminent danger which he feels is to the organization or to the society, he can report it to the particular inspector. Clear till here? Now we are done with that. Then we come directly to your next part of the chapter, okay, is your section 16 onwards. Can you tell me your section 16 onwards talks about what? I told you. It starts with the core of the chapter. It is about your occupational safety for health and working conditions code. First we did the duties of the employer, we can write in our own words. Duties of the employees, we can write in our own words. Okay, nothing complicated. Even now the heart of the chapter starts from section 16, but ultimately I told you which is important. 18 to section number, what I told you? 32. So 16 and 17 not that important. Let's see what is 16 and 17. That also we can go fast. Section 16 and section 17 has been set up by advisory boards, the government of India. Let's say there are, how many governments are there in India? Central government and state governments. For central government, they have made a national advisory board. What they have made? National board to advise them with respect to occupational safety, health, working conditions. And your state government also, they have appointed an advisory board for advising them on state level activities. Understood? State board. Till now, did you find anything very important? No. These are just basic authorities that you are putting, basic things that they have said, that the central government shall set up a national board to advise them on standard implementation and policies in respect to OSHWC. Same thing for the state government also. Now, till now, can you tell me what is the provisions that the government has done for OSHWC? Answer is no, we don't exactly know, because now the thing will start. Market is important. Section 18 to 32. So now we start your section number 18 to 32. Okay. Okay. Now 18 to 32, what all do they talk about? They talk that, listen, there has to be proper safety equipment, safety officers, safety committee in the company. Okay, in the company, who will look after whether that particular industry is, or that particular establishment is incorporating proper safety measures or not. Okay, so let's see. First is section number 16. The central government is empowered to prescribe certain standards to ensure protection of workers from workplace hazards. So what is the first thing that the government is going to do? What they will do? They will prescribe standards for safety of the employee. So they will tell that for X industries, these important standards have to be followed, right? So we also have so many, for so many things, government gives certain standards which we have to follow. Similarly, the first part. So what is the first steps that the government will do to protect them is to prescribe standards. And these standards could be with respect to factories, mines, dock work, building construction, BD, cigar and other establishments. So they will notify certain standards for various particular industries. Then what all these standards will cover? Scope of these standards. What do you think these standards will cover? First, they will tell that how to deal with your industrial hazards, industrial, dangerous activities which involve physical, chemical, biological, and other activities. So, and the employees do not suffer impairment of health or functional disabilities. Okay. So they will say about identification of hazards. They will tell that what all issues can be there, how treatment can be done in handling certain substances which are dangerous, hazardous substances, how much exposure level will be given or is allowed in a particular organization, medical examinations free of cost, and evaluation procedures for safety audits, etc. So here they will give that when audit should be done, where what are the hazardous activities, how to deal with hazardous activities, etc. Clear? In addition to that, they will also talk about occupational disease. So now section number 18 is saying that they will have standards for everything, and they will also speak about occupational diseases. Occupational diseases are those diseases which normally arise from those kind of occupations. Some diseases which arise from certain workplace. For example, those who are working in cigarette factories, they are normally, because of the small particles, they have a lot of lung diseases. So if a person has worked into a factory which deals in cigars and cigarettes and BDs, and he acquires an occupational disease, a lung disease, so should the employer pay him compensation? Yes or no? Yes. So the government will detect such kind of problems and provide that how to deal with it, how much compensation is to be given, etc. Clear? Section number 18 clear? Yes, that is prescribed standards for all those things and occupational diseases. The next thing that the government has said that we will appoint. Now, government cannot really cover all the scenarios. Yes or no? Every industry can have its own different risk. Every place, every factory can have its own different risk. So then they said that in every factory where they have a certain number of people, they should hire a safety officer and safety committee. So you will have to constitute safety committees, okay, and appoint safety officers to ensure the implementation of these measures. Okay. And whenever any committee is made under entire labor laws, they have equal number of employers and employees. Same representation is given. Now, market is important when these safety officers are to be appointed. Safety officers. So, employer shall appoint safety officers in the following establishment. Very, very important. Very important. That today, if I am going and seeing that there is a 500 or more workers in a factory, I will say where is the safety committee, who are the safety officers. If it is not there, it is a non-compliance, penalty will be there. So employer shall appoint safety officers wherever a factory has 500 or more workers. If it is hazardous, if it is dealing in certain hazardous processes, maybe into chemicals or into some fireworks or some other thing, then we will say that even if you are having 250 or more workers, you have to appoint a safety officer and safety committee. Concept clear? In normal cases 500, but I'm dealing in hazardous, then they are saying that at 250 only you keep a officer. Okay. For construction line, okay, now in building construction workers, employees, 250 or more workers, they should also have. And mines, It is 100 or more workers. So once there was a particular client, okay, those who had come to us. Now they were really. Now imagine factory workers who are not factory, they were working in a building, and that person who was working in that building, he had come. His wife had come actually. He said that her husband was working in the building, and he had climbed up those particular bamboos, and he had gone up. He fell from the seventh floor. So when he fell from the seventh floor, obviously, and this was a real life case, that he fell from the seventh floor, he was hospitalized. They had taken him in emergency to the particular thing. He survived, but he had multiple broken bones. Okay, so now the question is that he should get compensation. Now, inquiry will start in that particular organization that listen, you are having a construction going on, building construction is going on. So many people are employed by you. Where is a safety officer? Where is a safety committee? I'll call them. I'll tell them what equipments have you recommended. How come he fell? Why safety belts were not there? So you are putting officers in place to ensure that the day-to-day functioning goes smoothly. If anything goes wrong, as an employer, I am bound to report it to the government. So incident reporting is there in our duties of employer, and that's when the inspector will come in, inspect the premises, start his inquiry, search, seize, arrest. All those things are there, and you can say in the end he can give the penalties. Concept clear? Next, we see the section number 23, responsibility of the employer for providing all this. Very simple. Now, above what we read was mostly safety aspect. Above what we read was what? Occupational safety, occupational diseases, standards for safety, your safety officer, safety committee. Now they are going to talk about your specifically about certain things. Can you tell me whose responsibility in the exam, if they ask you, whose responsibility it is to provide health, safety, and working conditions in an organization? Is it rocket science that the employer is liable? Obviously, so it's very simple. Section number 23 is put in place so that employer knows that tomorrow if anything goes wrong, he was responsible. So this we will write under section 23 that the employer shall maintain all this and he shall be responsible. Now we are going to see some kinds of things that he has to provide. First, as an employer, what all do I have to provide? Just think, if I'm an employer, I will provide that there is a proper hygiene, cleanliness, proper ventilation should be there. Dust, fumes, harmful particles should be removed. Adequate humidification, because sometimes humidification means what? If someone is working in a factory, don't you think you will feel hot? Sometimes so the proper temperature which is suitable for human beings, proper cooling arrangement should be there, proper ventilation should be there, window should be there, air flowing should be there, drinking water facility should be there, it shouldn't be overcrowded, adequate lighting and proper latrine and urinal facility should be there, separate for male, females and transgenders. So this directly you can write as per section 23. These are the things that should be provided by the employer. It is the duty of the employer to provide. Now you'll see not major things have been given, very basic things have been written that give them ventilation, give them proper air, maintain it clean, ensure that there is no overcrowding, give them proper urinal facilities, separate. Obviously it will be men, women, and they have also added transgendered separately. Then they are talking about welfare, section number 24. So till now, can you tell me that we can write section 18, yes or no, above? In section 18, what all we had? 18 to 22, safety officer, safety committee, etc. Then we can write about section 23, responsibility and what all responsibilities are there. Concept clear? Now next we will write about section number 24, which is welfare. We'll write about 24, which is about welfare. Sir, what welfare facilities can we provide? Now welfare, if you see now, is a little bit more than basic. Now it is all the same thing only, but welfare just looks a little bit more than it, somewhere close. I can't say luxury, but little more than basic. Let's see. Washing facility should be there separately for men and women. Very for them this is luxury. That we have a proper bathroom, we can have a bath, washing, we can wash our clothes. For them that is luxury. For you it is basic. But think from their point of view, that the employer shall provide. For them this law is saying is welfare, giving them washing facility. Second, giving them proper bathing facility if they want to have a bath also. Now though it is very basic, the bathroom if they want to have, obviously it will be separate for men, women and transgenders. Okay, this is luxury. Next we see facilities for drying. Now obviously when they are washing, next thing what they would want, drying of those things. Okay, so drying of wet clothes should also be there, is a luxury. Then after doing washing and drying, they would want to sit in the side and talk. So you also give them proper sitting arrangements. Okay, and after sitting, don't you think after washing, having a bath, all of this, then they feel hungry, then they should also give what? Canteen facility. So employer will be like, a picnic you've come. Okay, but still this is the basic, it's considered under welfare. You have to give, very important, because whenever you see a threshold, like safety officers, I want you to write down the thresholds. Canteen facilities, when it has to be provided, whenever there are 100 or more workers. And very important, while eating, let's say someone was eating and then while eating continuously he fell and he injured his head, he hit the chair and he injured his head. So then what we should do, also we should have a first aid box. So we'll get that, what do you call it, the bandage, and we'll completely wrap him up and tell him to walk. So he will walk like the Egyptian mummies and then take him to hospital, right? So basically this is called as first aid box also. So these are welfare. These are very basic stuff. A little more. How will you take him? Will you tell him that like this, after putting him in bandage, walk till the hospital? We can tell them, right? Walk. But law has said no, don't do that. Give them a proper ambulance. Ambulance facility should be there whenever there are 500 or more workers. So these thresholds which I'm marking, you have to write it, because this is exactly what you will write and which is a core of the chapter as well. Next is medical facilities. Now imagine if it's raining, what we should give them? Umbrella, no? Because in umbrella, if you see that even it's just the hair that doesn't get wet. If wind is blowing, it's literally useless. What is recommended? Raincoat. So they will come, all of them in raincoats to work. So that's a luxury. Welfare category. Okay, uniforms will be given, restroom has been to be given to them. Okay, shelter, lunch room separately for all of them. All of the welfare, we saw all these things. Welfare officers, now imagine safety officer was there, now they are saying even welfare officer has to be appointed whenever there are 250 or more workers. So what does that mean? That very simple, that welfare, now I told you safety officer just looks at the safety angle. No injury should be there, no occupational diseases he should get, all those things of annual health checkup, those things. Welfare is about a little bit of luxury while working in the factory. I have my own washroom, I have my own restroom, I have my own canteen, etc. So that aspect will be seen by the welfare. Temporary living accommodation for building workers should be given free of charge. This is the law. If you see these building construction workers, don't you see that a particular workplace, certain kind of shelter homes have been given? The law has told them that temporary living accommodation is to be given. Then comes a very interesting provision which is also there, which is called as creche facility. It's one of the best things I think is there. Is creche facilities are daycare centers for children below the age of 6 years. So this is mainly creche is those daycare baby which is there. Okay, so for small children or like those infants who are less than 6 years, so this is a baby. Now let's say working women are there, they might have to take the child with them, yes or no? If you see small children, do they stay most with the fathers or with the mothers? It will be with the mothers only. Fathers, moment a boy baby starts crying, they will find the mother. Where is she? Give it. Only when the child is in happy condition, it comes to the father to play. If anything goes wrong, immediately father and the baby both will call the mother only. Okay. So this in factories they are saying if there are creche facility, daycare, when you see all this in some malls, they give you those small playing areas for children below 6, that should be provided. Okay, when you have 50 or more workers, this facility has to be provided. Concept clear? This, and then you will conclude your answer that the above are basically the provisions for health, safety and welfare as prescribed by central government. Is the concept clear? Yes or no? So we have completed what all is for the health, safety and welfare. Safety officers are there, welfare officers are there, and for health all those checkups have been provided. Now we go to your next part. Till here it is clear? Yeah. So heart of the chapter we are almost done. Now only one thing we are coming here. So we have done till here. So we have done duties of employer, employee we did. Occupational health and safety we can write directly from what I have told you. First you can write the national advisory board, state advisory board was made, and then you start with all these provisions together, you can write and conclude it. Your answer is done. This is what I feel is can come. And not only this, even this, these two are together. Then sorry, till here. Okay. Now we are seeing this other part is about your hours of work, annual leaves also. So this is also very important thing with respect to leaves. You tell me, if you're working in anyone who of you all who have ever worked, don't you think that leaves is very important? Annual leaves, because you get paid leaves, right? And how many paid leaves you can get, what you can, how many you can carry forward. Now my question is, let me see before I teach you the provisions, can an employee encash his paid leaves? Yes. So basically they can go and tell that, listen, I have so many paid leaves, I don't want to use the leaves, you give me cash instead. That is allowed. That is what we will see. Okay. So this is the provisions for annual leaves from section 25 to 32. Let's see. Now here I'll directly come to the part. Now the leaves and all of this I have summarized it here. So you can just build a 5-mark answer looking at this summary. So this is the summary. First thing is, imagine I have worked for 2 days in the organization and I am saying please give me cash for the leaves that is there. Allowed or not allowed? I come for 2 days, I work, 1 day leave I want. Will they give me? No. The leaves provisions, all the provisions to get paid leaves is applicable to workers only if he has worked for how many days? 180 days in the year. So half a year you work, then you talk about getting paid leaves, right? Common sense. So this is first thing. So I will say, yeah, I have worked for more than 6 months. I am entitled to leave. Now question is, how many leaves am I entitled? How many leaves? Unlimited leaves? No. So law is saying that leaves, how many will accrue? How many do you get? Is basically 1 leave for every 20 days worked. So if I work for 20 days, how many leaves I get? 1. 40 days, 2. 60 days, 3. Like that the leaves are accumulated. Understood? So these are the bare minimum provision. If the employer wants to give more provisions, he can always give. Understood? Now this leaves accumulation is for adults. This 20 days you work, you get one leave is for adults. For adolescents, adolescents are basically who are not completed 18 years. They can also work. They will get a little more benefit. If they work for 15 days, they will get a leave. Clear till here? So from employer point of view, is it useful to employ these adolescents according to you? They might come at cheap labor, that's all, and I can put them into things which adults might not fit into. If imagine I want to just fit them into some hole, I would prefer a small little child going there, right? Adolescent. So whatever they can employ, it is entire option of the employer who they want to do. But for 15 days they will get a leave. Adults will get on 20 days they get a 1 day leave. Clear? Now imagine some people who don't like going home only, because at home they are always tortured by their family, so they don't like it to go home, so they prefer to stay in workplace only. In workplace they will say, I have washing facility, I have drinking facility, I have canteen, I have all those facilities, let me stay here only and work, I don't want to go home. So they don't take the leaves only. So all those leaves, even let's say I work for 20 days, I have 1 day leave, I'm not using those leaves. So all those leaves get what? Carried forward. But there is a limit on how many carry forwards of leaves I can do. So how many maximum leaves that can be carried forward? In a year, you can carry maximum 30 unused leaves. Maximum carry forward of leaves. So can I carry, imagine one entire month of leaves I'm carrying forward. That is the maximum, right? It makes sense. Beyond that, they won't allow. So beyond that, if the leaves have accrued, what I will do? Unused leaves, what will I do? Encash it. Tell them, listen, I have 32 leaves. I can carry forward only 30. 2 leaves money give me. So I can ask for fifth one, payment of unused leaves can be asked to encash it. Okay, employer must pay the wages for the leaves, earned leaves that the worker did not take. Concept clear? Now the question is, with respect, if you see any horrible employee is there, like if you say the torturist employer is there, what do they do now? They say, yeah, there are false promises. I'll pay you. Law is saying now I have to pay you. I'll encash it. I'll pay you. When I won't say it. Pay you after I get some money. I'll pay you tomorrow. I'll pay you after 1 month. I'll pay you after 2 months. I delay the payments. Employee can't do much. So law has prescribed that this payment also of his unpaid leaves has to be paid within a certain time period. What is the time period? Within 2 working days. Isn't it a nice concept? Imagine if he is removed or there is a resignation. Payment of the unused leaves should be given in 2 work. He's leaving the job. He's leaving the organization. So then that amount is not going to come back. So you have to pay it within 2 days immediately, 2 working days. Then you see the time limit on retirement or death. So if there is a death or retirement, it can be paid within a span of 2 months. Okay. So again, if he is resigned or he is going away, so it seems that why will someone be removed? Why will someone resign? Maybe there is a dispute going on. So then the law says that end the matter quickly, just pay it and close it. For other cases where there doesn't seem like a dispute, there's a death or retirement, so the amount also might be a little more. So then they give you 2 months time. Concept clear? And then comes encashment of leaves. That this, so we've already discussed that leaves exceeding 30 days may be encashed, that is got the cash. Clear? Can we write the provisions of leaves entirely out here? That is it. Clear? This is what you will write. It's very beautiful to build a 5-mark answer. So your annual hours of work and annual leave. So how many? Now one more thing. This is for especially for employers like Narayan Murthy. As an employee, do you like to work as how Narayan Murthy is saying? He's saying you have to work how many hours in a week? 70 hours. So that seems very pro-employer, not pro-employee. So law has said, listen, that if I'm saying 70-hour week means he wants you to work 10 hours in the organization. Those kind of employers, you can tell them that as per section 25, the working hours shall not be more than 8 hours a day. So in addition to what I'm telling you, annual leaves, hours of work is also there. So market is important. So I will look back at Narayan Murthy and say maximum how many hours you can make me work in a day? 8 hours. I want you to write it. Now, for motor transport, I told you this entire law is also applicable to those drivers, motor vehicles who are driving. So for them, they have said that they also have been giving working hours, but their working hours will include. Now imagine if my job, this is point A, this is point A. My job is to go from point A to point B. Okay, now pay attention to what I'm saying. Point A is the warehouse, and this is my factory. Now imagine if I want to call the goods from my warehouse to the factory. I appoint a motor transport worker who will take this tempo. He will load the goods, he will do loading here, and he will do unloading here. Yes or no? Common sense. Now the question is, how many hours is he working? Let's say if his journey is of 3 hours, and for loading the goods he has spent half an hour, and here for unloading also he has spent half an hour. So what is his total working hours? 3 hours or 4 hours? Common sense, 4 hours. 3 hours is his driving time, and even the loading hours and the unloading hours should be added. So that's what they're saying, that for motor transport workers, when we are calculating their working hours, include the running time, the journey time, include the waiting period if sometimes he had to wait for tolls, etc. That also should be included, and even the loading and unloading time should be included. Clear till here? Now we see for journalists. Now journalists and sales promotion employees, a little, because this act is also applicable to journalists. For journalists, they have given hours of work that we can make them work. So if you do the maths, you will come to know that they have been given a lot of benefits. That maximum we can make them work is 144 hours in 4 weeks. Okay, and at least 24 hours of rest in every 7 days. So that means on Sundays they get an off. So in a week, 1 day off is there. This is 24 hours of off in a week is what they are saying for journalists. Similarly, they've given it for your sales promotion employees, some time limits for hours of work. And one thing you have to remember, that whenever they tell you overtime, that this is the normal hours of work, in section 27 they are telling you that if you want to make, and this is the constant provision in all the 4 laws, all the 4 labor laws, it is the same. Whenever I make an employee work for overtime, I have to pay them 2x. If their salary is X or their wage rate is X, for overtime how much I have to pay them? 2x. Concept clear? So twice. So if the per hour rate is 1000, then if I'm making him work overtime more than that 8 hours and all those times we have seen, then I will have to pay them twice of the normal payment time. Clear? That is it. Okay, with this we have completed your entire thing. Now we'll see the other part. So this was the core of the chapter we have completed. Now directly we can go into the provisions. Now I told you with respect to inspectors, I will teach you once, and all the other 4 labor laws you will see it is the same. First of all, a code is a book, yes or no? It is a book. A code is a document. So can a code by itself ensure that the act is followed? If I make an act, you think that it can ensure that everything is followed? Answer is no. You require officers to enforce it, punish it, that is when people will follow. Only when punishment is there, lockouts are there, search, investigation, those kind of enforcement bodies are there. So in everything they have appointed a officer. Government appoints a inspector. Okay, inspector nowadays can do web-based investigation also. Means what, nowadays in GST and your income tax, notices are said online on the registered email ID, and reply is also given online. So this is web-based investigation. What will be the powers of these investigator, of these inspector? Now my question is, do you think that these powers of the investigator is only for this code, for all the four codes? What do you think? The powers of inspector that we are going to do now is for this code only, or for all the four labor codes? Obviously the inspector or any inspector will have these only powers, na? Common sense. Power to enter, power to inspect, power to inquire, power to call for records, power to search, seize, arrest, power to issue show cause notices, power to take photographs, samples, measurements, and initiate prosecution. Now they have also said that the government might have third party auditors also, third party audits and certification, empanel certain experts for conducting safety audit. Imagine if I am saying that I have proper safety in my organization. Government would want to check it or no. They would want to check whether it is sufficient or no. So for audits they can appoint certain experts. So government will say that we want to do a dedicated audit into your organization whether proper safety measures are incorporated or no, because we have got some complaints or there was this incident, now we want this audit to be done. Right? So I have seen unfortunately so many times, it's so heartbreaking. Sometimes we've seen in hospitals there have been fire, people have died. Yes or no? Sometimes in some government schools, many children have died. Sometimes in all these buildings have collapsed. Why? Because proper investigation or audits were never done with respect to its safety, whether they are viable, not viable, habitable, not habitable, whether they have, so many times I've seen, if you read the papers, then government will come and say that we are going to give some kind of compensation to the families of the people, etc. And they'll come and give 5 lakh rupees. So that is really not the correct way. Government should ideally keep checking all these hospitals on regular basis. Audit should be done on a more frequent basis, right? Then I told you one other important topic, but very simple, not much is given here, but it's important. That special provision for women has been made. For women have been made. Section 43 says that first, can I employ women in night shifts? Yes or no? With their permission you can employ. Nowadays the entire, because they have first initially they said that after 7 p.m. you cannot employ women. Now as an employer, when I know men are ready to work and women by law prohibited to be working after 7, I will not hire women. It will adversely affect. And nowadays the work culture is such that if the work is there, there is a deadline. People, men or women, whoever it is, will stay after late night also and complete the work and go. This is how it is there. So simple, government has recognized that, and it is a very welcome step that they have done. That first they have made a provision that women are entitled to be worked in all establishments and all types of work. Section 43. Second, they said that they may. This was earlier not allowed. Now they have said that they may be working before 6 p.m. and beyond 7 p.m. Means after 7 p.m. and before 6 p.m. during that, this is a night shift. This is completely about night shift. Night shifts are also allowed with their consent. And when they are hiring women in dangerous operations, they should provide proper adequate safety. Concept clear? Done. Now we look at the provisions of contract labor. Now we are coming to another part which was a separate chapter altogether, which they made is called as contract labor. Let's see. Now, first let's understand the meaning of the term contract labor. Very, very important and provision. Okay, so there was a separate act which was called as Contract Labours Act, Prohibition and Regulation Act. Now they have made a as a part of this only. It's chapter number. Which chapter is it? What I've given in the notes. Which chapter? Chapter 11 talks about contract labor. Do you know the meaning of contract labor? You know. Okay, very good. So let's see. For understanding the provisions of contract labor, first understand this arrangement, that there is a principal employer. I want you to just draw it with me. It'll be easy for you to understand. Principal employer is there. This principal employer normally hires contractors. Who does he hire? Contractors. These contractors further employ other people. Okay, they employ certain people. They are called as contract labor. What are they called? Contract labor. So if I have to define, so is this hierarchy clear? That an employer hires a contractor and this contractor hires contract labor. Now this comes in cases of buildings. Have you seen all these building constructions which are there? Building constructions. Let's say, give me an example of a employer, a principal employer, or the person, a big real estate company. Who develops? Give me any names. L&T, very good. Any others? Famous developers around your area. Luda, Piramal, Oberois, okay, etc. So these are very Rustam ji. These are, I don't know in your area which is there. Now imagine if I'm taking of Lodha. Okay, I'm taking a case of Lodha. He is a principal employer. But to construct the building, do you see that those very people from migrant workers come from other states? They get a shelter home, temporary accommodation. Then they will pick up all those bricks and go. So those people, you think that the Lodha is directly hiring them? No. Lodha hires a contractor. Lodha hires a contractor, and this contractor will hire those people. Will have a network of these people. So if I have to define who's a contract labor, the contract labor is a person who is hired by a contractor. Is the contractor doing the work of his own thing? No. By a contractor on behalf of the principal employer. On behalf of principal employer. Is it clear? Now the question is that what about this code? How is it connected? Now the question is about their safety, their health. What is the chapter about? Their full form: occupational safety, health and welfare and working conditions. Yes or no? So who will provide them this facility? Well, because there are two different people, right? It is this person also and this is this person also. Who I will put the responsibility to give these facilities to the contract labor? So very simple, welfare facilities with respect to staying, washing, canteen, all those things. Who is responsible according to you? It is the principal employer. Obviously, they have the money, they have hired. So for all this, the responsibility is of the principal employer. Clear? But one simple part, the payment of the fees or payment of these charges, payment of their salary, whose responsibility is to pay? See, they are all those daily workers, right? They come, they get paid. So who do you think will pay this amount? So the wages, daily wages, etc. Whose responsibility is to pay the daily wages? Make a logic, make a guess. Contractor. Obviously, contractor will pay this thing if the contractor has not failed. He has failed to pay. So contractor has primary responsibility. If contractor has failed to pay, then these people will run to know the principal employer and the principal employer will have to pay. So they have primary responsibility. Who? Contractor. And secondary responsibility is of principal employer. Concept clear? That is one thing. That's it. This is the core provision given under section 53. Under which section? 53. See this. Core provision directly I'll tell you. That section 53 says that the liability of the principal employer to pay the welfare services. The contract labor receives welfare services. It is a principal employer who must provide the welfare facilities relating to health, safety, working condition and welfare. This entire code responsibility is on principal employer. Concept clear? But when I see the other things with respect to payment of wages is section 55. Section 55. It is financial responsibility to pay is on whom? The contractor is primarily responsible to pay the wages to the contract laborer. Okay, and this can be paid through electronic, any modes of payment is fine. If the contractor fails to pay these wages, then who is responsible? Principal employer. Clear? Now in 56 they have said the experience certificate, that if some employer, contract laborers wants to get an experience certificate, so it is the duty of the contractor and the principal employer to issue a experience certificate to the contract laborer, and then we can conclude. One just point is there that today if anyone wants to hire contract laborers, they have to get a license from the government, and this license they will see whether you have proper ability to give that, otherwise a license will be cancelled. That's all that you need to know for your particular part. Clear till here? Done. Now directly we come to the end part, which is common in all the chapters. I told you is the offenses and penalties. So very first thing is, if there is any offense, who will ideally be responsible? This you can write and you will see it will be relayed in all the 4 codes. So that time I will go faster. If there is any particular code, who is responsible? So ideally the officers in charge who have control over the factory or the particular establishment, they will be responsible. There is given a defense also. That if they can, because in a company there can be multiple people who are involved. If anyone proves that it is without their knowledge or negligence, an act has been done, then they will be protected. Means if tomorrow because Ambani is there, he must be having hundreds of factories. He will say that, listen, I am the principal employer, but I am not the direct person who is responsible, or I don't have the knowledge, or I don't have the direct responsibility. So that defense he can take. We will try to figure out that who is directly responsible. Then comes, if the company has been found guilty of any of the offense, then one thing they can do is called as compounding. What it is called? Compounding, or called as composition. Composition is some kind of a settlement. There is a settlement that you can do by paying fine, by paying some money, called as compounding charge. I'll pay it and I'll close the matter. Clear till here? Now, when you do the compounding, you have to understand that this compounding, normally I settle the matter. It shouldn't happen that I keep repeating the offense. Yes or no? So law says that within 3 years, if you do the offense, it cannot be compounded. If you repeat an offense within 3 years, that act shall not be compounded and proper case will be started. So it's very dangerous. So I have to wait for how many years to do the offense again? 3 years. After 3 years, it will be treated as a fresh offense, and if I do it, I can go and compound it also. But within 3 years, repeat offenses cannot be compounded within 3 years. Now they have given you compounding means an offense is settled by payment instead of going through prosecution. Type of case, if it's penalty is there, penalty is mostly in civil matters. So 50% of the penalty they will levy and close the matter. For example, if the penalty is 10,000, they will say just pay 5,000 and close the matter. If it is punishable with fine, now fine mostly shows a criminal little bit more serious. So therefore the fine, to compound it, how much we can charge? 75% of the maximum fine. Clear? So I will see that if the maximum fine is 20,000, 75% is the maximum compounding charge that I can take to close the matter. Once the matter is compounded, that is settled, then no, you don't have to worry, no proceedings will be done. Now imagine I go to the office and I say, please compound it, settle the matter. They say, okay, fine, pay the compounding charges. We'll settle the matter. They told me to pay, I did not pay that compounding amount also within the time limit. So additional 20% of the fine will be levied. If there is a delay in paying the compounding fine only, so then again 20%. So it's a penalty will be levied again 20%. And compounding will not be allowed if you repeat the offense within how much time? 3 years. Now they have made again a social security fund. So we are done with compounding and those. Compounding will just pay the fine and close it. Okay, then no prosecution will go ahead. But you can't keep repeating offenses. So within 3 years you are not allowed to compound again for the same offense. That's a simple little point. Now we see social security fund. So fund means what? There is money or no money inside. Money. Funds are really good. Okay. Now the question is where this fund will be used. Social security. But you think this fund will be used for benefit of Ambani and his children, Adani and their children? You think? No. It's for social security, and social security for unorganized workers. For unorganized means they don't have proper facilities, life insurances, proper safety, etc. For them, they are the unorganized sectors. They have a concept called as gig workers. Have you heard of gig workers? Gig workers are those workers which are outside the employer-employee relation but are employed in the company. Like your Swiggy delivery, your food delivery workers, they are not formal employees. They are just doing work on contractual basis. So for them, they are at the highest risk. They are unorganized sectors. So government has created this fund. It can be used to benefit these people. Okay, now money, who will put the money inside? The sources of this fund could be the compounding charges when anyone pays, it will go in this fund. Okay, penalty amounts can go in this fund, and these funds will be used for benefit of workers. Okay, or of these unorganized workers. That is it. Now just remember this part, that with respect to the thresholds, I have just made a particular thresholds also towards the end. Those numbers that you need to know. When we did the initial chapter, occupational safety and health, threshold requirement 100, you have safety workers. 250, you require safety workers if there is a hazardous, this is for mines. Okay, 500 in normal cases. Clear? Thresholds that you can see. Then 50, you have to keep a restroom. 100, you have to keep a canteen. 250, you have to keep a welfare officer, and 500 or more, you'll have to keep a ambulance room. Okay, these are all the corrective benefits that have been given under this code, and that is it. We have completed the entire chapter in depth and along with all the examples as well. Take care, guys. Thank you. Okay, now we'll start with the next code. Okay, let me know. Great. Now we'll start with the next code, which is the next code, your lesson number 17. Okay, lesson 17. It's called as Industrial Relation Code. Okay, let me know clear in the chat box if it is clear to you. Okay. So we'll just take a 5 minute break and then we will start with this chapter. Okay. So 5 minutes we'll take a break. Maybe at 2 p.m. we can start in 10 minutes. At 2 p.m. we start with this chapter and we will complete it. Hi. So now we'll begin with the next code, which is your industrial relation code. Okay. So great. So am I audible, visible? Let me know in the chat box so we can quickly start and complete this particular topic. Now, many students are asking, can we use it in professionals? Obviously, yes, it's the same code that we are doing. So it's not from those executive or professional or LLB point of view. I have covered the full code, means from the bare act. So it can be used by anyone because the sections will be the same exactly. Okay. So now we will be starting. Let's see. Hi, so we'll be starting with the next chapter, which is called as a Industrial Relation Code 2020. Now, again, similarly, as I told you, any particular code you are starting, you have to write the introduction. In the introduction, you will write that why this has been made to maintain proper good relations between the employer and employee. And for that good relations, they have some sub points also, and every single labor law was passed after the National Law Commission recommendation. So all these labor codes were passed, 4 labor codes were passed after the recommendation by the second Law Commission on Labor. It got its presidential assent on 20th September, and it became official on 20th, it was published in the official gazette in 29th September 2020. Now, in this particular code, 3 major laws were subsumed. Again, I told you that labor codes have been a combination of the previous laws. So 3 major acts were there: Trade Union, Standing Orders Act, and the Industrial Dispute Act. These 3 were clubbed to make your industrial relation code. Now, before we start any answer, any topic, we will write the object of the code. In every single code, they have given you the object of the code. Why this code was made? So this code was made to consolidate the laws, that means combine all the laws with respect to trade union, standing orders, and to settle industrial disputes. Now we will look what all are the sections and how many sections we have to study. So nothing can come outside this act, obviously, because the total chapters we will be seeing. So nothing can come outside of what we are doing. So the first thing is your chapters. How many chapters do you see is there in the industrial relation code? 13 chapters. How many sections do you see that is there in the industrial relation? Is your 101 sections. Now from here, I told you that 3 major laws were clubbed. Which were the 3 major laws? Trade Union Act, Standing Orders Act, and your industrial disputes. So from here, I think even you can identify which is the heart of the chapter. When I say heart of the chapter, means the core important provisions. So obviously it would be contained in your chapter 3, that is your trade union, your chapter 4, which is your standing orders. But let me tell you, both these acts are not that important. Both these acts are very small. The main provision in any law you could identify itself is industrial disputes. How do you decide and how do you deal with a dispute? How many authorities are there? What if there is and this industrial dispute is your strike. There are 4 things in industrial dispute. Okay, strike, lockout, retrenchment, layoff. If any question comes, it would be from your strike, lockout, retrenchment, and layoff. This is what I expect. The main provisions of the chapters are contained here. Okay, in this particular thing, from year to year. So this is what you should know. Though we will see the overview of all these other provisions also, but this becomes the heart of the chapter. Any exam question would be from this. And they talk about 4 important things that you should know: strike, lockout, retrenchment, and layoff. So these are 4 things that is there. So as the heart has 4 chambers, Similarly, this also has 4 important provisions. Let's start. The first thing is your Trade Union Act. Trade Union Act. Now, Trade Union Act is covered from your section 5 to section number 27. What does it really say? It says that employees can come together and form a trade union. A trade union is a means of collective bargaining, because if an employee goes alone, workman goes alone, he will not get his demands. But if collectively all of them go and form a trade union becomes a separate legal existence. So it is a body corporate. What is a trade union? It becomes a body corporate. So what does body corporate means? Means it is having a separate legal existence. It has a separate legal existence. All this you can write with trade union. Okay, the separate legal existence. If it has a separate legal existence, so what? So then it can sue and be sued. So the main objective is to sue also. If the employer has not done properly something, so they can go ahead and sue, and it amounts to a collective bargaining in the hands of the employees. Clear till here? So here we will see in this chapter that how today if I am working in Reliance and all the employees want to go and set up a trade union. So how they can go? They have to go and give an application to the registrar of trade unions. That registrar will go and see that you require 7 people and then a certain number of people from the organization or the industry in which you are setting up the trade union. Once he identifies that sufficient people are there connected with that organization, he will give you that congratulations, your trade union has been formed. It will have separate legal existence and it will be a body corporate. Concept clear? Now introduction, if they ask what is a basic trade union, a trade union is a organization. A trade union is a union or an organization of workers to protect their interest and collectively bargain from the employer for wages, for working conditions, job securities, etc. Concept clear? The provisions of trade union are covered from section 5 to section 27 of the Industrial Relation Code. Now first thing is, sir, if someone wants to set up a trade union, so the section 6 says that if you want to set up a trade union, 7 people are required. Public company, how many people are needed to set up a public company? Minimum number of people, 7. Here also it is same. 7 or more persons can of a trade union can apply for registration. Moment they apply, then and who will they apply to? They will apply to the registrar of trade. So the state government, section 5 says that the state, every single state will set up a registrar for trade union to receive the applications and register trade unions. Concept clear? Now let's say 7 of us, let's say all of us were working, we apply to the trade union, and now we will apply to the registrar that please register a trade union so we can now protect all our interest. The registrar will say, show me how many people are employed in that organization. Well, I cannot set up a trade union for Tatas without being employed in Tatas, right? Minimum number of people will be there. So minimum membership requirement is how much? At least 10% of the workers or 100, whichever is less. So this is the bare minimum workers that have to be associated in that establishment or that industry to be allowed to be set up a trade union. Concept clear? So 7 people will come. Then they also need to get some number of workers who are there associated with that organization, and then it will be granted. Clear? If you don't have both the conditions, minimum 7 workers and minimum 7 members, and the worker requirement 10% or 100, whichever is less, then your trade union will be denied. So these two has to be there as a continuous requirement. It has to be there. If the members falls below this, membership level falls below this, and the registration might be cancelled. Concept clear? Now very simple, that when these 7 people come in and they would want to register the trade union, what all do you think they will give in the documentation? Now I'll give you an example. Since you are a company law student, company secretary student, you already know that to form a company what all is needed. What are the documents that a registrar of companies will require to incorporate a company? MOA, AOA. What does MOA contain? Name, registered office, subscribers, capital, and AOA contains the rule, regulations, bylaws. Same thing is given here. Name, objects, purpose, who are the governing officers, what all benefits are there. Same points will be there that you have to give the details. So your entire rules, regulation, bylaws will be given to the registrar for incorporation. Clear till here? That is it. Okay. Then in section number 9, the trade union will be registered. You will get a certificate of registration. It is conclusive proof that the particular trade union has been formed. Okay. And it will be registered. And it will become a body corporate. A body corporate means a entity which has perpetual succession, common seal, can sue and be sued, can enter and hire people as well. Clear? Now, one very interesting point that they have added in trade union, which was not there next time earlier, okay, which is very interesting as well. It is immunity from civil suits. I found it very interesting as well and very important as well. Let's understand. A trade union is a body corporate. They might be having the, like in your particular building also. So there is something called as a managing committee, right? What is there? Managing committee, right? So they are actually the office bearers, the main decision makers in a particular body, a particular body corporate. Now what happens? Imagine if I'm the employer. Think from this point of view. I am the employer, and these are the employees. Is any employee showing me the face? No. They all will come in the form of a trade union. Trade union will send the notice that we want this, otherwise we will go on strike. They're threatening the employer, right? I don't know who's the trade union because they are coming in the form of a letter. It is also trade union. Sign is also trade union. I don't know who's that employee who's going and putting the key and I'm getting these notices. So the employer said, what I will do now, these office bearers, they are the main people running. I will put a case on them. Criminal conspiracy. What case I will put? If I want to scare the hell out of these people, I will put a case of criminal conspiracy, that they all are trying to conspire, do a kind of we can say colluding together and trying to do some criminal activities, and I will put a FIR and get them in jail. Don't you think I can actually disrupt the trade union? I can buy out certain police officers, I can get them on my side and send a notice. So that used to happen. I would directly file a case that these people are coming together and doing criminal conspiracy. So then they said that under this section that is impossible now, because immunity has been granted to the office bearers from any kind of criminal proceedings because they are simply acting for the trade union. Interesting, yes or no? So no civil suit, and even later they have told criminal suit for criminal conspiracy. So they can't even file any case. In civil suit they will say asking for damages. No civil or criminal proceeding shall lie against the trade union or the office bearers for any act that they have done in furtherance of an industrial dispute. Okay. So this is a protection for any kind of civil or criminal liability. Even can I file a case of criminal conspiracy? No. So no office bearer shall be liable for criminal conspiracy. So both civil and criminal case cannot be filed on the office bearers simply because they are trying to further the lawful objects of a trade union. Clear? That is it. Okay. This you can remember. Now this was about trade union. You can set up with the requisite number of people and now operate, and even the office bearers and the trade union are protected. Clear? Now we come to the second act. The second act is your chapter 4, which deals from your section number 28 to section number 39. It's of your industrial code. First thing is your standing orders. What is the name of the act? Standing Orders Act. First, let's understand the meaning of standing orders. I'll tell you, standing orders, even before understanding standing orders, let me give you the picture before the act. Before the Standing Orders Act, what used to happen? Prior to this law, I'm giving you the legislative history of why this act was passed. Now imagine if I am hiring these blue collar employees. Blue collar, see, white collar, what job we do is white collar professionals. But if you go to see those people who are the factory workers, they are blue collar jobs. So do you think that when we are hiring them, we enter into formal contracts? We just tell them start working from tomorrow. They come, we pay them, finish. So there is no written contract. What used to happen? There was no written contracts, and because nothing was written, all the terms and conditions were heavily in favor of the employer. All the conditions of work and terms of employment were in favor of the contract because there were no written documentation. Clear? So government recognized that, and they said that listen, we will make something called as standing orders. Standing orders are called as written down rules for conditions of work. What do you mean by the term standing orders? It means written down rules for conditions of work. In conditions of work, just like if you're getting employed in the employment agreement, what all will be written? When you will get a leave, what is the dress code, what all benefits you get, when you can be removed, how much time notice should be given for removing, how you will enter, when your fine can be cut, when the payment will be done. All those standards of which you get in a contract normally will be written. Concept clear? Now they have brought in, so what are written standing orders? Let's read. Same thing what I have told you. Standing orders are written rules of conditions of work in an establishment. They regulate such as hours of work, how many hours you have to work, etc. The written standing orders help get a clarity, uniformity and discipline in employment working conditions. Till here it is clear? Yes. Now very important, where the heart of the chapter is there. Two types of standing orders. I'll explain. Now there are two types of standing orders. Standing orders. Do you know how many types are there? Two types. Which are the two types? One is called as model standing orders. One is called as model standing orders, and the other one is called as certifying standing orders. Certifying standing orders. Okay, now pay attention. This is the heart of the chapter. Model standing orders are those standing orders which apply to any establishment by default. So they are applicable by default. So they are applicable by default. By default. Okay. So today, if a organization is, and government has given the model standing orders already. Model standing orders are written rules and conditions. Government has set it up. So today, if I am hiring a blue collar worker and I have not entered into any written contract with him, by default, what will apply? The written down standing orders which the government has given, which is called as model standing orders. So after this Standing Orders Act, all employees were hired, got the bare minimum services which was mentioned in the model standing laws. By default, the contract of the law applied. Understood? Now the thing is, for employers, now this was the basic features, basic provisions that the employee would get. But imagine employees like Tata's were saying that listen, we want to give more beneficial conditions. We want to give them something better, greater. Then in that case, don't you think government will allow? Yes. So they will obviously allow it. So then they will have to certify the standing orders. They have to certifying standing orders have to be approved by whom? By the certifying officer. The certifying officer will come and approve it. Now you think, because see, common sense, the employer will say I'm giving better condition, but someone has to look that written down whether it is really beneficial or no. So when the process, so in this chapter, what question they can ask you? What is the process of certifying the standing orders? Because there's nothing else only left. Model standing orders are already given. Your company can ask you that we have written down some better working conditions, go and get it certified. So the process of certifying the standing orders will be given. Now what will be the process? Very simple. Who will make the standing orders first according to you? My question is, who will make these standing orders first? How does the process start? Who will make the standing orders? Employer. Employer will come and make the standing orders. They are called as draft standing orders because they are subject to approval. Once these draft standing orders are made, then this he will give it to the officer. He will give it to the certifying officer. That, sir, you please see this and approve it. The certifying officer will first study it himself, satisfied whether it is genuinely beneficial or not beneficial. Then he will say, let me give it to the trade union and the workmen. Then he will give it to whom? Trade union and the workmen. He'll give it to them that I'm giving it to them to approve it. Then after they approve it, then it will be published. After they approve it, then it will be published. After they publish it, then this new standing orders will apply to the establishment. Concept clear? So very simple. I give it to the office. First I draft it. I give it to the officer. He will check it. Then he will give it to the trade union and the employees to check it. After both of them have approved, then he will say, okay, we all agree that it is more beneficial. So now again, how many standing orders have been given? Model standing orders and the certifying standing orders. What they can ask you in the exam is only one question, is what is the process of certifying the standing orders? Procedure for certifying the standing orders. Market is important. From this topic, only one question they can ask is how can we certify the standing order? So you will write the entire history and then the procedure. First is you have to prepare, the employer will have to prepare what? The draft standing orders. This draft standing orders will contain all the terms and conditions of work, everything will be given. Then he will give it to the certifying officer. The certifying officer will then give it to the employees and then it will be certified. Concept clear? Now, duration and modification of the standing orders. Can I keep modifying these terms and conditions again and again? So they say 6 months you wait. So you cannot modify a standing orders from the 6 months of the last modification. So if it has been modified now, the next modification can happen after 6 months. This is the base rule and that's it. You have completed with this part. One other thing they can ask you is subsistence allowance. What they can ask you? Subsistence allowance is called as living allowance. Living allowance given when there is a pending inquiry. Okay, let's understand the concept. Subsistence means to live. So living allowance is given. This is also one part which is given in your section 38. You can mark this also as important. It's very simple. Imagine a employee has been removed. Has not been removed, he has been suspended. What he has been done? Suspended. Pending an inquiry. We are checking whether he has done something wrong or no. Inquiry has been removed. Is going ongoing. So we have told him that now you sit at home. You think those blue collar jobs can sit home without salary? They will say that inquiry is going on. It will go long. Till that, will I get paid or no? So yes, you will get subsistence allowance. So how much you will get is given here. So first of all, subsistence allowance refers to the amount paid to a worker during suspension because the investigation is pending. Why it is given? To give him basic financial support so that he can live during the suspension period also. Now, how much subsistence allowance is to be given? So for the first 90 days of suspension, for the first 90 days he will get 50% of the wages, and post that he will get 75% of the wages. So if someone is being suspended for the first 3 months, how much salary he'll get? Half salary he will get. Now let's say the inquiry also should get over quickly. If it is not getting over quickly, it is the employee's fault. No. So then they say then after the 90 days he should get 75% of the remaining period. That is it. Concept clear? Clear? So during suspension you get paid for the first 90 days 50% of your salary, and after 90 days you will get 75% of your salary. That is it. And then once the suspension is over, then based on the inquiry they will decide whether to keep you or no. This is just the allowance to be given during suspension. Okay. Now we come to the heart of the chapter. What is the heart of the chapter? I told you. Industrial dispute. Now in industrial dispute, the main thing that they can ask you are only four things. And this is what I feel is the most important part of the chapter. The first thing is called as strike, lockout, retrenchment, layoff. These four things you have to know properly. What is a strike? What is a lockout? What is a retrenchment? And what is a layoff? In LLB also they ask this only. So let's see, one from here I think you already know. Strike. Strike is basically by employees. Have they left the job? Have they terminated? No. It is a suspension of work by the employees, the workmen, that they are refusing to work till their demand is met. That is called as strike. Now, what if the employer is unhappy with the performance of the workmen? So even he can have a power. He can also have a weapon called as lockout. Lockout is suspension of work by the employer. He puts a factory lockout. He puts a lock on the factory. He said, "I will not open till you all stop harassing me." So lockout is has he removed them? No. It is a temporary suspension of work by the employer. It is called as lockout till their demands are met. So strike is a weapon in the hands of the employee, and lockout is a weapon in the hands of the employer. So if you go to see this, your what is a strike? It is basically a refusal to work is called as strike. If I say refusal to employ, not removal, it's just temporarily I do a lockout, it's called as lockout. Strike is done by whom? Workers. And lockout is done by whom? Employers. So many years back, Maruti, they had not given bonus, so the employees resorted to violence and they broke down the factory, the cars, etc. So this Maruti company didn't like it at all. They said that till you don't apologize and till all the people who have done wrong are not punished, I will declare a lockout. Don't you think that lockout is valid? So we will also have to see whether the validity, if it is valid, then we will see whether wages should be given, not given during all this period. Next is retrenchment. Nowadays, if you don't upskill, can I say that the jobs are also at threat because of AI and automation? The need of manual work by humans is literally not needed. So what we will tell, so many IT companies, they inform all their developers, etc., that we are removing you. So can I say retrenchment is a termination of employment? In retrenchment, what are you doing? You are termination of employment for reasons other than disciplinary action or retirement. Means it is not that I'm taking disciplinary action against you. You're not done anything wrong. Neither have you retired. I'm removing you due to business reasons. Okay, I don't know. I want to downsize or I want to automate. That is simple. So now the government has said that whenever you have retrenched anyone, you have to give him some compensation. That is called as a reskilling fund has been brought in, which I feel will come in your examination. That government is saying that because you're removing them, give them some money so that they can go and reskill and upskill and get a employment back. In layoff, what happens? It is a temporary, temporary shutdown due to reasons such as no SAM, business reasons. Suspension of work for no SAM. What is no SAM? There is a natural calamity. If there is an earthquake, can you ask everyone to come and work? I'll tell them to keep moving and work. Natural calamity. So, any other reason? Shortage of raw materials. Imagine if there is a shortage of raw materials, like I don't have it's an employer's fault, okay, or for business reasons, I didn't have that many raw materials. How they will come? So they are coming and sitting in the factory, but I don't have work to give. So it's called as a layoff. You go home. Accumulation of stock. Imagine if there is so much stock may come that there is no place, and it will take time for us to adjust it. So I will also not be able to employ you till that is all sorted. And last is breakdown of machinery. Machinery is not working, electricity went away, so how will it work? So on all these cases, is there a dispute here? No. Have we removed them? No. What I have to do, simply that due to these reasons I cannot employ you for business reason. Tomorrow come back and work. That's it. Are these four terms clear? That's it. Now we will be doing them in depth. Okay. Now this I want you to learn, and also learn the section. Very rarely I tell you to remember the sections in labor laws. This is one of them. Section 2Q. Any answer comes, you can write that industrial relations. I'm giving you the introduction also that you can write. Introduction, when industrial relation, these four has to come out of this only. That's my analysis, that from these four only you will see your question. So when you start, write with this. Industrial relation may lead to conflicts between employer and employee. Therefore, the code has, defined certain concepts such as industrial dispute, strike, lockout, retrenchment, layoff to regulate such disputes and bring in industrial peace. It's a to bring peace, industrial peace. It has been introduced. Now, when we look, what is an industrial dispute? Industrial dispute means a dispute between employer, worker, and with related to matters such as employment, non-employment, terms of employment, or conditions of work. So this, obviously you will start your answer giving with the section. Section 2Q. It defines what is a industrial dispute. So industrial dispute is a dispute between employer, workman, or workman. All of them, they are fighting before employment, non-employment, terms of employment, or conditions of work. Clear till here? Done. Now let's start with the chapter. Okay, let's start with the key provisions. Now, first thing is the definition. The definition also you should ask. They can ask you a question like what is strike, what is lockout, what is retrenchment. Sometimes they ask difference between them. The concepts are clear, you can do it. So strike simply means a collective stoppage of work by the employer, by the employee. Means strike we know. Collectively they are saying that we will not work. Now they have given that one part called as casual leaves taken by 50% or more workers together is also called as a strike. Market is important. I feel this they can ask you as a question. This is very important. This is what, if I would be there, I can make a question like this, that in a company there were 60% of the employees took a leave together. Don't you think it is like a mass bunking? There must be some kind of issue that shows that can also be counted as a strike. So normally strike is where I verbally say and I stop the work saying that my demand should be met and I am refusing to work till the demands are met. That is a strike. But a casual leaves taken by 50% or more workers at the same time is also said to be a deemed strike. What it is? A deemed strike. Imagine mass bunking in class. All of them, they are not there. So this is this is a weapon in the hands of the workers. Now similarly, similar to strike, a lockout is opposite of strike. It is where the employer temporarily closes his workplace, he puts a lock and refuses to employ till his demands are met. So it's a temporary closure, suspending the work and refusing to employ, okay, till his demands are met. Now this case law you can always write in the exam. Very few students will learn case laws. This I am saying you can fit it very beautifully. Express newspapers versus their workers, and it's a very simple that strike is a weapon in the hands of the employee. Similarly, lockout is a weapon in the hands of the employer. This we can always write. It's a common sense question, but you quote it with the Supreme Court case law. Clear till here? Done. Next we see your retrenchment. What is the meaning of the term retrenchment? What I told you retrenchment means, this also I feel is extremely important. Retrenchment means I tell you, we're very sorry, we can't employ you. You have not done anything wrong. Neither are you retired, but still I have to remove you for business reasons. Termination of an service of the worker, except, so it does not include termination due to disciplinary action, retirement. Superannuation is compulsory retirement. This was voluntary retirement. Superannuation means compulsory retirement. Expiry of contract, ill health, that is not retrenchment. Retrenchment means there is absolutely no problem, no issue, work is ongoing, but I have to come and break the news to you that I have to remove you due to any particular thing. Excess manpower is removed. Now when I come to layoff, section 2T, have I removed him? No. I have not removed in layoff. Layoff sounds like you have removed, but that is not what the technical meaning is. It means a temporary failure or unable to provide the employment due to some business reasons. And which are those business reasons given? No, Sam. Natural calamity, any other reason, shortage of raw materials, accumulation of stock, or breakdown of machinery. Concept clear? That is called as layoff. Now, the important provisions here for strike and lockout, market is important. Very, very important. Section 62 and section 63. Okay. One, they tell you prohibition of lockout by employer and prohibition of strike by employee. Understand? Section 62. This is again very important. This you have to quote in the exam. Section 62 as well. Now pay attention to this. What is the weapon in the hands of the employees called? Strike. This is for employees. And what is the weapon in the hands of the employers called? Lockout. This is for employers. Concept clear? Should a employee go for strike? He just opens in the all the trade. They say let's go strike tomorrow. Can they do that? Can the employer suddenly go and lock the door? No. So there is a general prohibition. What is that? There is a general prohibition to do a strike. In short, rules for strike have been given. How strike can be done. Rules for lockout has been given. How lockout can be done. And when lockout cannot be done, when strike cannot be given. Those provisions are contained in section 60. Which section I told you? 62. This is what you will write. Now very simple. First there, and the provisions are exactly same. The conditions for strike is also same and the conditions for lockout is also the same. For example, let me ask you, if there is a pending case going on in court, matter is already pending before court, arbitral tribunal or any proceedings anywhere, before any labor court, can you go for strike or lockout? Common sense, no. If any matter is pending in court or before any arbitrator, before any authority, can you go for strike or lockout? Obviously not. Na? They are saying matter is pending. How you are going now? Let the decision come. This is the base rule. 4-5 points get over. So both, even in strike, the employees also cannot go because matter is pending. Employees also cannot go because matter is pending. Concept clear? Now let's see what other points have been given. So section 62 gives you the prohibition. First, notice requirement. Now pay attention to this. Okay, this you can note down. Understand this concept. Both of them is there. Section your 62. All these points are there. That worker must give a prior notice to the employer before striking, and the strike must take place within 60 days of giving the notice. 1. I gave a notice and I have to do a strike within 60 days. Second, no worker cannot go to strike within 14 days after giving the notice. After giving the notice, within 14 days he cannot do. Means if you are threatening a strike, you have to do it within the period of 14 days to 60 days. Means after giving the notice, so once you give the notice for strike, and this is same for strike or lockout. Once you give the notice, within 14 days of the notice I can't go, and after 60 days I cannot go. So this is the minimum period I have to wait and this is the maximum period I have to wait. Concept clear? Understand? 14 and 60 days. Understand how it is placed. Law says that listen, you have just given a notice. In the notice, can I write that I'll go and strike the very next day? No. Employer also should get some time to negotiate, explain it to you all. So within 14 days of giving the notice, you cannot go for strike. Concept clear? I just give you the notice and I say we are going for strike, that is not allowed. So within 14 days of giving the notice, you cannot go. So you have to wait minimum for 14 days after giving the notice to go for a strike. Clear? Now the thing is, I gave a notice and 16 days are lapsed. I'm not going for strike. That 61 days, I'm waiting for 1 year, 2 years, 3 years. Then can I go and strike? I say I had given you a notice in 2 years back. They say, that notice also will have a validity. No, it cannot be left open for a long time. If later you want to do, give a fresh notice. So this is the time zone within which the strike will happen. After 14 days, before 60 days. We don't want early also, we don't want very late strike also. So notices cannot be kept open is what they want to say. After that, the notice will become stale, will become useless. You have to give a fresh notice. 14 days and 60 days is clear. Rest all is same. That one thing, I cannot do a strike before the date specified in the notice. For example, if I say I will do a strike on 25th Jan, then I cannot do a strike before that. If date specified, you cannot strike before that. Clear? Now see, all this is same. That if there is any conciliation proceedings pending, or if there is any tribunal proceedings pending, or if there is any arbitration proceedings pending, or a settlement award is in operation, something is ongoing, so you cannot strike. Clear till here? Exactly same points are for employer also. Employer also cannot just do a lockout. 14 days he has to wait after giving notice, and maximum he has to wait for 60 days. Within this range only he will do a lockout. He cannot do a lockout before the date specified in the notice. He cannot do a lockout if there is any conciliation or any tribunal proceedings or some arbitration proceedings or some settlement proceedings ongoing. Concept clear? That is it. If you have done any act which is violation of section 62, then that strike will be treated as illegal strike. And if you do a lockout against section 62, then that lockout will be treated as illegal lockout. Concept clear? What is a illegal strike or lockout? If it is done in contravention of the act. Clear? Done. Now the thing is, with respect to layoff, okay, with respect to compensation for layoff. Now remember one thing, this is not directly given, but I'll explain you how it works in practical life. Okay, now imagine if I want your attention here, okay, because you can get confused. Let's say if strike is legal, if it is proved that the strike is justified, and if it is proved that the strike is illegal. Okay, now pay attention. If it goes in court and the court decides that the strike was done properly and as per section 62 and all the demands were also valid. If it was legal, will the compensation be paid? Salary be paid during the strike period? Will salary be paid during the period of strike? In this case, we can say salary, wages will be paid. If the court rules that the strike was done wrongly, will the salary be paid? No. Concept clear? If the same thing is for, now imagine if the same thing is for, it's not a strike, it is a lockout. What it is? Not a strike, it's a lockout. Lockout is by employer. Okay, now you tell me whether salary will be paid or no. Now you have to think and tell me. Okay, because question in this thing is, during the strike or the lockout, do we have to pay wages? So it depends whether it is legal or illegal. So let's say is, if the lockout which the employer did, it is proved that the lockout was legal, will salary be paid? No. Because the employer was justified in case of Maruti. Employees had done a violence. So it is justified not to open the factory. If it is proved that the lockout was illegal, it was not as per the law, then in that case will we pay the wages? Yes. That is the provision for strike or lockout. Now we saw about with respect to layoff. Strike, lockout is clear. It depends whether it is justified or not justified. Now when it comes to layoff, in layoff what happened is, imagine due to reasons such as no SAM, earthquake was there, natural calamity was there, etc. I couldn't give him the work. Let's say there was a light went away. He came to the office, he came to the factory, and I could not pay him. I could not give him work. There was no electricity. Do you have to pay him salary for that day? Full salary, half salary, how much? He didn't work, right? But how much salary do you have to give in case of layoff? Very simple, they are being fair to the employer also. Otherwise, the employer also will go bankrupt if he has to do every time. Okay. So they give how much? 50% of the BA plus DA. In the salary structure, when you see there, they tell you how much is the basic, how much is the dearance allowance. So amount of compensation for layoff. For layoff is how much? 50%. Half only you get for basic plus DA. He's sitting at home, right? We are not taking work from him. We are telling you come in, you go. That is it. Now, coming with respect to retrenchment. So have you understood the how much we have to pay them in strike, in lockout? That is there. In layoff, you have to pay 50%. And now we are coming to retrenchment. Retrenchment means termination of of the employment only. Now the thing is, if any person has worked for 1 year with the company, they have worked for how much time? 1 year. And now we are telling him, we're very sorry, we are removing you, not for your mistake. Then there are some rules that have to be followed. First is, while removing him, we have to give them a notice in writing that sorry, we have to remove you. Second, we have to give them retrenchment compensation. In all these cases, we are seeing compensation. Retrenchment compensation is how much? 15%, 15 compensation equal to 15 days average pay for every completed year of the continuous service. Now again, very important. Imagine in this case, what is happening? We are removing the employee. Is it good? No. First is you have to give them a notice. A proper written notice is mandatory. Second, I have to give them money, compensation. That is 15 days pay I have to give for every completed year. So if he's worked for 15 days, let's say if he's worked for 1 year, I'll compute the 15 days salary, that is half month salary, right? So let's say half month salary is coming to 20,000. So if he's worked for 1 year only and 15 days salary is 20,000, how much I have to pay him? 20. If he's worked for 2 years, 40. 3 years, 60. So I will pay for every completed year. So 3 years, then accordingly I'll do the multiplication. Clear till here? Now this is also very interesting. I think they can ask you, because this could be in today's time as a labor law advisor, I believe this provision of retrenchment can come very common, because companies ask lawyers and company secretaries that now we want to remove these employees. How do we do that? What is the laws? So then we will tell them that you cannot just remove anyone you want. I can't just cherry pick and give retrenchment notices. I have to use the last in first out rule, that who have joined the latest, I will first have to remove them. Do I remove the oldest employee or the newest employee? The newest one, right? So last in, who just came, will be the first out rule. So when workers of a particular category are to be retrenched, the employer should ordinarily retrench the workers who was last employed in that category, unless he has given a proper reasons for removing someone else. Concept clear? Next is, imagine I call an employee, I say, I'm very sorry, you've been working with us, and in your position as XYZ, I have to tell that I have to remove you. So will he be happy or sad? I tell them that, listen, due to some manpower software I've incorporated, which you were only building, now you are no longer needed. So he will be sad. Now imagine he is saying, don't worry sir, I am being loyal with the company for 5 years. This time if the company doesn't need me, I will leave. I say, okay, fine. Thank you so much. Don't forget, we are cutting a farewell cake for you. Do have the cake and go. We cut the farewell cake nicely. We give each other. We put his status also, my last day at office, etc. And then suddenly, when he's seeing the particular websites, that Naukri, the company has posted a new job requirement on the same position. And in this job, there's one vacancy. We need one human. So is this right or wrong? Wrong, na? So they have also said that listen, if you're retrenching people, don't hire them. And if you're hiring in that position, then give the old people a second opportunity. You didn't break their heart, right? Imagine now we have just cut the cake and a new person is coming for job and we are hiring him. So retrenchment is if the employer proposes to hire workers within 1 year, then preference should be given to the retrenched worker. After retrenchment, if you are planning to hire again, we have to give the opportunity to the retrenched workers. Clear till here? Now, even when we are shutting down the establishment, shutting down the establishment means what? Business is only closing down. So all of them will be retrenched. Okay, so again we have to give them compensation as discussed above. How much? 15 days for every year completed. Okay. Now just one thing is, earlier what we did with respect to layoff and retrenchment was for small establishments which had less than 300 workers. Here we have 300 or more workers. If there are 300 or more workers, okay, in that case almost same provisions are there for layoff and retrenchment. Only thing is the rules are different for big companies. Now imagine provisions for layoff and provisions for retrenchment for large establishment. Earlier we saw notice period has to be given for how many months? 1 month to remove him. Now you will see that did we require government approval to do all this? No. But now imagine if a company like Reliance, Tata's or big company comes in, this provision will be applicable. It's similar to what it is there, just some additional safety measures are put in. So where a big organization is there, the rules are slightly different, more protective in nature for the employees. So they say that if you want to lay off anyone, you require prior permission of the government. It does not apply to sudden layoff for earthquakes, etc. It is not needed, but you have to inform. Okay, prior permission is not required if the layoff is due to shortage of power, natural calamity, fire, gas explosion. This time you don't need to take, but when you have written any other reason, in no SAM, O is for any other reason. If it is there, then you require government approval. So for layoff, you require government approval. Concept clear? For big companies who are employing more than 300 people. Rest everything is same. And also you see, instead of 1 month notice, how many months notice you are giving? 3 months. And prior permission of the appropriate government is needed. Rest more or less it is the same. Clear till here? Rest same provisions you can write. The retrenchment compensation is also the same. 15 days average pay for every completed year. Clear? For closure also, if a big company wants to close down, same thing. Earlier it was written they can close down, but they have to give compensation. Here same points they will write, that you require prior permission of the government. What do you require? Prior permission of the government. Concept clear? That is it. Now when I told you that when we are retrenching someone, now this I think is going to come in your exam. Reskilling fund. What it is called? Reskilling fund. Section number 83. It is connected with retrenchment. When we had retrenched a person, we have to pay him some money. How much money we have to pay? 15 days salary will be paid for every completed year. This thing the employer will put it in a reskilling fund, and from the reskilling fund he will be paid in 45 days, because the timeline also in how much time this money should be paid is mentioned here. So section 83 is covering that. Let's see. What does section 83 talk about? Your workers reskilling fund section 83 that a fund will be made for reskilling. Now reskilling is whenever they have been retrenched in retrenchment, so that they can acquire a new skill to improve their chance of re-employment somewhere. Who will set up this fund? Government. Where the fund will come from? Employer will pay. Government can also put in some funds. And how much the government, the employer has to deposit? Amount equivalent to 15 days pay for every year. Okay, that he has to pay, and this 15 days wages drawn by the retrenched worker has to be contributed into this fund. The amount of the utilization of this fund will be used for drawing the amount equal to 15 days wages, which we had discussed for the which was there, has to be paid to the employee, but the timeline has been given. In how much time you have to pay? Within 45 days of retrenchment. So an amount equivalent to 15 days wages has to be paid to the retrenched worker within 45 days from retrenchment. Okay, and then you have this labor unfair labor practices that have been given is in your section number 84. What are some unfair? You can just have a quick read. That what are unfair labor practices? Imagine if the employer, unfair means he's doing something wrong. So if the employer is trying to interfere with the trade union, is trying to victimize anyone, discriminate anyone, or do illegal lockout, these are called as unfair labor practices on behalf of the employer. If I see unfair labor practices on behalf of the workers, is basically doing an illegal strike, using force means coercion, using violence, or trying to go slow by working really slow and damaging the equipment. So these are all unfair practices on the behalf of the workers. Now we see the provisions of compounding and offenses will be the same. If a company is there, if this I told you is common across all the 4 labor codes. First, if section 88, if anyone has done wrong, who will be held liable? Company and its officers in charge. They can take a defense that they were not directly responsible and they had exercised their due diligence, is what defense they can take. Then compounding. Compounding, I told you the meaning. Compounding means payment of certain amount and settling the case. Once the case is settled, then no proceedings will be taken up. Now fine. How much amount of compounding charges can be taken? 50% of the if fine is levied, then 50% of that. If imprisonment and fine is levied, then 75% of the maximum fine levied. For example, if it is 1 lakh rupees was given as fine, then how much I can take as compounding charges? 50% of that is 50,000. If it was year, then 75,000 will be taken as settling or compounding charges. If it has been settled once, and I'm happy that I made an offense, but however I use the compounding provision. Within 3 years, I am not allowed to compound again. So I have to wait for 3 years to repeat it. Okay, that is there. And with this, we have completed the entire chapter on Industrial Relation Code. Thank you. Done. Now we will start with the next chapter. We will take let's say a 5-minute break and start with the next chapter. Okay. So let me know in the chat box if it is clear and you understood or not. Next is your code of wages. Code of wages. And then after that we have your code on social security. Hi. So am I audible and visible? Let me know in the chat box. Now it's time to knock out another one more chapter. Okay. Thank you so much, Pritesh. Okay, great. And Karthik, Shantanu, are you all there? Great. Shobha, Sahik. Okay, great. So we will be starting with one more topic and covering that also. That is called as a code of wages. Let me know in the chat box if everything is good to go. GTG in the chat box. Good to go. Chalo, great. So we will start with the chapter. Hi, so we'll be starting with a chapter called as Code on Wages 2019. Now, I told you before we start writing about any labor code, it's equally important to start it well by writing the introduction. So, in the introduction, we will be writing that the code on wages, and you have to prepare your introduction really well, where the examiner feels that you are the one who drafted these codes. Okay, after later whatever happens is fine, but introduction should be, because that's in your hand, it's almost like certain what you're going to write. So the code of wages consolidates the law relating to, we will see all these things. Four major acts have been clubbed here. Which one? Equal remuneration, minimum wages, payment of wages, and payment of bonus. All of these four labor codes have been merged. They have made a uniform, by combining it, they have made a uniform law with respect to wages. And it was notified on 8th August 2019, and there are only 9 chapters covering from section 1 to section number 69. Okay, so now if you see here your code of wages, very simple, small act, should get over quick. Here we are, 69 sections. And how many chapters? 9 chapters. So this is the legislative framework. First is, there were 4 codes I told you, and all those 4 codes are in different chapters. First is your Equal Remuneration Act, chapter 1. Minimum Wages Act, which was there, is now in your chapter 2. Your Payment of Wages is your chapter number 3, and your Payment of Bonus. That is it. Rest all is a replica of other codes, like Advisory Board, Central and State Advisory Board is there to obviously advise about wages. Then they have said that inspector related provisions, that an inspector will be there to search seats, arrest, give notices, etc. Same offenses will be given, that if you do an offense, of company will be held responsible, person in charge. However, if they use a defense that they were not responsible or not without their negligence, then they will not be held responsible. And then they give you about the compounding. Same points in all the codes, it's the same. One point, they also say that if anyone wants to claim this, for example, if how do you claim the, how then the, if there is an injury or someone wants to claim, then they made these labor codes in that the any of the person or the legal representatives can go and claim. So essentially 4 labor codes, that 4 chapters that we need to do, 1, 2, 3 and 4. Let's see, 1, 2, 3, 4. This is it. In the start only the chapter gets done. First, the code on wages. What is a code on wages? It's a code which consolidates 4 important labor laws, all related with wages, making a uniform law in India with respect to wages. Section 1 is called, gives you the name, it's called as a code of wages and covers the whole of India. Now definitions are given. We'll directly go to the chapter. Okay. Your chapter number 1, chapter 1, section 3 and 4 talks about equal remuneration. Earlier there was a topic called as Equal Remuneration Act. This is now become a part of Labor Code, chapter 1, section 3 and 4. So which sections we need to know? Only 2, section 3 and section 4, and equal remuneration is over. Now you tell me, can one pay more salary to men and less salary to women for the work which is same or similar? Is it right? No. So it goes against our constitution. Article 14, equality before the law irrespective of gender. Article 15, no gender discrimination. Your against our constitution, directive principles of state policy. Article 39D, which states that the state, it is the duty of the state to ensure that in the country equal pay is given for both men and women. So in line of the constitutional provision, this particular has provisions has been introduced. What is the logic? Men and women should get same pay for same or similar work. Clear? It says that there should be no discrimination on the grounds of gender. Now, when I say same work or similar work, what does it mean? Now, what does the work same work or similar work mean? How can you define it? So any work which requires the same amount of skills or effort or experience or responsibility will be treated as work of same or similar nature. Concept clear? Any work which requires the same amount of skills, efforts, experience or responsibility will be treated as work of same or similar. Now, we have to do two sections. Which two sections? Section 3 and Section 4. The main provisions are contained in Section 3. Section 3 has two subsections, subsection 1 and subsection 2. Subsection 1 is the base rule, no discrimination. It states that no discrimination should be there among employees on the grounds of gender relating to wages when the work is same or similar. Concept clear? Same thing we have said 4-5 times. Second, they are saying there has to be no reduction of the wages to of any of the employee. For example, if there was, now imagine it's a very funny situation. Now let's say there were two employees. Okay, these two employees were there. He was getting 30,000 for the same job and for the same work. The girl was given how much? 25,000. After they both were having lunch together, they discussed their salary and she broke down. She said that I'm getting less for the same work. So this guy said, I will not tolerate this. I will go and speak to the management. You don't worry. I'm there with you. Not only here, but anytime you need me. He goes to the employer and he says that for the same work you have given her less pay, I will not tolerate. The employer says, I'm so sorry. I'll make both your salaries equal. What he will do? He reduces the salary of the guy to 25,000. Allowed or not allowed? Not allowed. That is what they are saying, that in order to comply with this provision, don't reduce anyone's salary. You should instead increase the salary to 30,000. So the employer says, I am joking. I just wanted to see 30,000 to both of you. Okay? Live happily, and now you all can live happily ever after. After the 30,000 they both got, they both applied somewhere else. Okay, so coming to the next thing, section 2, section 3, subsection 2, subclause 2, no discrimination in recruitment. Okay, at the time of recruitment only can you discriminate on the grounds of your gender. For example, if an airline company is hiring an air hostess, can they do discrimination on the ground of gender? No. So obviously, air hostesses and the male same work when they do what are they called? Purser. Yes. Stewards. Great. So basically the same, no discrimination at the time of hiring. Also sometimes they say we want only men or only women. This should not be done. Okay. Now section 4. Now 3 was the main core provisions. What was 3? That no discrimination. Don't try to reduce the pay and try to complying with this provision. And no discrimination at the time of recruitment only. Okay. And section 4 says decision as to, now this is a very basic thing, that Where there is a dispute, it will be handled by the government. If there is any dispute with respect to work of same or similar nature, then it will be decided by the government. Simple. Our first provision is done. So do girls have to agree to lesser pay? Answer is no. Men are standing with you in this fight. Okay. Next, coming to your minimum wages act. Now the minimum wages was incorporated in your chapter number 2. Chapter number 2 goes from your section 5 to section number 14. Write it down and directly quote in your exam also. Minimum wages is chapter 2 section range, at least you can write. Let's see what is minimum wages talking about. Okay. Now don't you think that in our country, I'll explain you what is a minimum wage concept and all the key provisions I will tell you that you need to know right now only. Okay. Minimum wages. Minimum wages is the bare minimum. Okay. Bare minimum wage that a employer should give. Okay, for any employment. Now who do you think will set the minimum wages? Obviously government will set the minimum wages. Now don't you think that the minimum wages could be different? Because minimum means what? It's if you don't give that, then they will not be able to survive only. Okay. Now you think and tell me that is the minimum wage should be same across different states, different regions and different types of work. You think they will give one wage for all? Obviously in village, rural area, the living cost of living is very less. So then what they do, minimum wages, the setting of the minimum wage, setting how to set up of minimum wage. Government will set up two modes are there. Two modes is there to fix the minimum wage, setting or fixing. One is called as committee method and the second one is called as notification method. In notification method, the government will directly post the notification, ask for feedback from the people and say that these are the minimum wages. If you all have any queries, inform us. We will hear it and then they make it live. The other one is the more common method is where the government appoints a dedicated committee. The committee will be an expert committee, will do the necessary investigation, check the different regions, type of work, what all different classes are there, prepare a report and give it to the government. Government on basis of this committee report will then set the minimum wage. Clear till here? Two methods done. While setting the minimum wages, various factors will be seen in mind. Factors while setting minimum wage. What all factors they will see? Obviously they will look at the type of work. Right. What type of work is there? Accordingly the minimum wages will be done. Higher difficult work will be paid a little more. Less time consuming work can be given this. Then you could see with respect to the location. In which region how much minimum wage should be set. Okay. Then other factors such as age, the gender, etc., how much you are incorporating, etc., could be set. Whether when I say age means what, for adolescent they might set a different minimum wage, etc. Now one last part about minimum wage versus the floor wage. Now can you tell me that the minimum wage is going to be different across different territories, yes or no? We just saw that we can't have one minimum wage throughout. So then they said it is different in different regions, different in different areas. What the government does, they makes now imagine to be a little fair, the government sets a national average, a national level floor wage will be set. Means government will say that no doubt minimum wages can be will be set in different regions, but it should never be below the floor wage. So for example, this is, I'll just go draw in, statistics we used to do graphs. Minimum wages can be, some places it will be high, some places it will be low, some places it will be different. Yes or no? In some places there is, some places your it would be there. What the government has done, they have set a minimum floor level. That, listen, I understand that different sectors will have different pay, different classes, but it should never go in the entire country below this level. This is called as a floor wage. Floor wage is one wage which is the ultimate bottom line. When any committee is also making, they should never set a minimum wage below the floor wage. Common sense. If there is a conflict, now understand this part. Now this is an interesting provision. If there is a conflict, that means floor wage is given something and minimum wage is given something. Which one will prevail? Which one is more superior? That has to be followed. So let's say floor wage was set as rupees 500 and minimum wage they set it as 300. Allowed or not allowed? Not allowed. This is not allowed. It is wrong. Then the person will get paid as per the floor wage only. Understood? If in any case a minimum wage has been set below the floor wage, the employee does not have to worry, he will get paid as per the floor wage only. Let's take a reverse situation where the floor wage was 300 and the minimum wage was 500. This is absolutely fine, because as long as it's not hit the floor wage, it is fine. The employee will get 300 or 500? 500. Obviously, because floor wage is a bare minimum. Everything should be above. Whatever is above, that will be paid to the employee. That is it. Now we can complete the topic. So first thing is your minimum wage. Now your minimum wage means what? You'll write an introduction whenever you're starting the section rate. Minimum wage is to ensure that the employees receive at least the minimum level of wages and it prevents exploitation. Okay, it is fixed by the government and it could be different in different categories. Section 5, payment of minimum wages. Can an employee pay below the minimum wages? No. No employer can pay employees less than the minimum wage. Now, fixing of minimum wage. You think there is one minimum wage across the country? No, that's called as floor wage. Minimum wage, the power of the government, state governments will set up the minimum wage. Types of minimum wages, it can be set up on basis of time or piece. For example, I can set up per hour. This is because looking at the industry, they will see that this is paid on per hour basis. Construction, maybe some kind of work is given on per hour, some is given on completion of a project. So they will be setting time or piece wage, depend on industry to industry. Now, criteria for fixing. What all factors you will look into? I told you some of the factors you will look while fixing the minimum wage. The skill required, the area, how much difficult it is, all these factors you will be seeing. Now they have given you components of minimum wage. Very simple. Section 7. You can write this if it comes. Interesting also. Imagine components of minimum wage. Minimum wage, when I'm giving, what all it contains. In your salary structure, when you see basic plus DA, that is a component. That's how it is shown. So here they are saying that you can show your minimum wage in 3 ways. How many ways? 3. And all of them are extremely similar. I have to pay him 2000, but I can show it as 1500 plus DA. So one method is I'm paying them 2000 only. How much I'm paying them? 2000. But I can show it differently. Basic is 500 and cost of living is called as DNS allowance is 500. So you got, so this component can be shown BA plus DA. This is common and your minimum wage is calculated. Or I can show it as basic plus cash value of concession. For example, I give him 1500 cash, and rest I give them some amount of coupon of 500 rupees cash concession. So I give them concession in food grains, that whenever you go to buy food grains, 500 rupees off. So ultimately you give him a benefit of how much? 2000. 500 direct cash and 1500 direct cash, and 500 rupees I gave them cash value of some concession. So some kind of coupon where they get a 500 rupees discount. So some they give you discount coupons, so where you get that benefit. So that way you're giving. Or the third one is, did you like all these nonsense? Or you'll say they're giving me 2000, just show it 2000 and close it. That is called as on inclusive, 2000 rupees. Instead of doing BA plus DA, this plus this, that's 2000 rupees, take and do whatever you want. That's it, done. Now, procedure for fixing of minimum wage. I told you how many methods are there? 2. Committee method, make a committee, listen to the committee and set it up. Or notification, put out a notification in the newspapers, official gazette, ask for feedbacks and then decide as per the feedbacks. Now we come to minimum wage we are done. Now we are talking about the floor wage. Market is important. Important, okay. Think and tell me which government will set the floor wage. Obviously central government, because it is going to be throughout the country. So to ensure a basic wage across the country, the code empowers the government to set a floor wage. It becomes a national level benchmark. Okay. And all the other minimum wages have to be greater than the floor wage or the floor wage. Means, can I say in one line, simple words, section 9, minimum wage cannot be lower than the floor wage. Right? That is there. And that is it. We have completed the topic as well. Now we come to the next thing, which is called as Payment of Wages Act. Section 15 to 25. Clear till here? It is your chapter number 3. So I told you 4 acts are there. This is the third act, Payment of Wages. Now if we see this Payment of Wages, what does it talk about? Object of the act, etc. I will tell you. I just made this diagram. I had made this image. Okay, I had developed it just to explain the concept. Imagine if this is the employee. If this is the employee. Now what is the name of the topic that we are learning is payment of, yes or no? When you look, this is the employer. Okay, and this is the pocket of the employee. The employer, two things. So you will understand the object of this act with the help of this image. Now imagine the employer, I'm the employer, okay. I bring in an employee, he said take 30,000 rupees your pay. I put 30,000 in his pocket and I tell him that you had not come on this day, cut. You had not worn formal clothes, cut. You had done this damage, cut. I had given you that house to stay, cut. That coming going, I had sent a car, cut. Like this, cut I am saying, and in the end I tell him you have to pay me 5,000. You think it is okay? Employee will he'll say you put in my pocket, now you're removing it and you remove 500 bucks more from my pocket. Allowed or not allowed? So the object of this act is to pay the wages, give them respect, pay them the wages without unauthorized deduction. Unauthorized deductions. So they will tell you what all deductions you can make, PF and all that you can cut. Unnecessary deduction, when you do, it is wrong. Pay them. And second, when I have to pay them, the other main core part of the act they tell you is the time limit when I have to pay the wages. Okay? Time limit. Time limit to pay wages. Means what? Very simple. Now imagine I have told an employee, I have to pay you 30,000. No? I'll pay you 6 months together. 6 months you work. Then you work for 6 months. Then I tell him I'll pay you 8 months together. And then I'll tell him that you work a little more, almost 8 months, 1 year salary I'll pay you together. We work for, this is what startups normally can, trick their poor employee. I'll pay you all together with all lump sum compensation all together. And on the last day, on the 365th day, they will tell them, we have some bad news. We have some bad news. Our company has got bankrupt. Okay, you have to pay some amount, so we will continue employing you. Okay, if you want a job, you have to pay some money and contribute as a capital to the company. You think this is all making sense? No, so this is wrong. So they have said that the wage period had been set. The wage period, no company today, no establishment today can set a wage period of greater than 1 month. So you have to maximum the wage. 1 month is over, you have to pay them. And within how many days of end of the month also they've given you? By the 10th of the month. So today when companies are there, they pay salary on monthly basis. You'll never see anyone pay bi-monthly basis. They can pay on daily basis, weekly basis, bi-weekly, not beyond a month, because the maximum wage period is 1 month. And after that also you will see that moment nowadays they are having this 10 days and 7 days depending on how big the organization is. They are saying that moment the month is over, January month is over, in the next 7 days you will see they pay the wages. Because as the law, as per payment of wages law, right? So as an employee, I know very simple that by 7th or by max 10th, I have to get the salary. That's the time limit for them to pay the wage of that month. By the next month, 7th or 10th, I have to pay. This is the chapter about. Understood? Concept done. Let's quickly complete it. Okay. So, payment of wages. Introduction. What is the chapter about? Section 15 to 25. That payment of wages. Very simple. That time to, what does it do? It's a time to make the payment of the wages and without unauthorized deduction. Concept clear? Now mode of payment, how I can pay them? Can I throw coins on them? Answer is yes. It's written coins, you won't throw it. All the wages can be paid in coins, notes, check, online mode, electronic mode is all allowed. So all kind, because you see all those blue collar workers, they don't really have bank accounts. So you can pay them the money as well. Clear? Second, fixation of wage period. Very, very important. What I told you, wage period is how much time zone you have to make the payment. Is daily, weekly, everything is there, but max monthly. Beyond a month, no wage period shall be greater than a month. Okay. Now coming section 17, extremely important. They say this, satra matlab khatra. So here also, if I am the company secretary of a company, I know as per section 17, it's high risk. I have to pay the payment, I have to pay the wages within a certain time. So all the employees will get their payment within how much time? Let's see. Mainly people are work for monthly basis, yes or no? Mostly in companies and all that, they are paid for monthly. So see within how much time? Before the expiry of the 7th day. Very important. Market is important. So in any big company you go, they will pay the wages before the 7th day of the next month. So January month salary will be paid max by 7th Feb. Clear? Then daily, then by the end of the day, very simple, no? Because daily one will have to pay immediately. End of the shift. Weekly, by end of the week. Okay, on the last working day of the week. Fortnightly means, fourth means 2. Fortnightly means twice. Okay, 14 days. Before the end of the second day after the end of the fortnight. The main important is monthly basis you need to know. If a person has been removed dismissal, retrenchment or closure, then it should be paid, the wages must be paid within a span of 2 days. Whenever you see now, it's mostly the same. Whenever this guy is going away, within 2 days you have to pay and close it. Now we come to section number 17, we did wage period and time limit to pay the wages, and now we see section number 18 is about the deductions. What deductions are allowed, not allowed? You tell me, if I'm deducting your PF, allowed or not allowed? Provident fund and all that is allowed to deduct now. Employees, you see, they are deducting, that all is allowed. If I'm giving a house to stay, that rent amount I can deduct. Yes. Any leaves he has taken which is unpaid will be taken. So all those are all valid deductions. So only authorized valid deductions are allowed. What is not deemed to be a deduction? Okay. Can an employee say that this is a deduction if I did not give him a promotion? Not giving a promotion, is it a deduction? No. That I am not deducted anything. Whatever salary I am paying, I am just not giving you an increment. That is a different thing. That is there. Or reduction to a lower post. Okay. Or suspension shall not be deemed to be a deduction from wages. So if I say that, listen, your job is horrible, I am demoting you to one level below, that is not a deduction from wages. I am reducing your position. That is fine. What all are permissible deductions? Again, very simple, logical. Any fine, any absence from duty, damage you have done, I've given you a house to stay, amenities you've given, you've taken a loan from the employer, any income tax which is told, any payment that has to be paid, trade union membership fees, all this is allowed. But you tell me that deduction if I do and I end up giving him only 2 rupees, allowed or not allowed? I'll say you take tails or heads. He said, no, what nonsense. Law says very simple that never can be a deduction greater than 50% of the wages. Means maximum limit for deduction is 50% of wages. Common sense, yes or no? Obviously, perfect common sense. Fines. Can we levy fine on the employee? Answer is yes, if he has done, anything which is, so first, why you're deducting the fines has to be written down in advance, that if you do XYZ activities, fine will be levied. And this has to be approved by the government. So fines can only be levied for approved acts. No fine shall be imposed on any employee except if that act or omission has been stated as has been notified with the approval of the government. Means obviously we cannot levy unreasonable fines, etc. So they are saying that why you are levying the fine, first go and get it approved by the government. Okay, and display it on the notice of the particular company also. Okay, now mostly this is it. Okay, and we've completed with the entire chapter. Isn't this image really good? It explains the concept. I have only generated it. Okay, now going to the sitting getting bored, I like, let me make one small little image. Now we make the payment of bonus act. Payment of bonus act is the last part, and then we'll be done with the code. So first thing is your payment of bonus, section 26 to 41. Now what is happening? This chapter is about paying some bonus to the employees. Now certain kinds of industries always have been paying bonus, and they will have to continue paying bonus even if they have less profits. And we will see how that bonus is given. They have decided the minimum bonus I have to give. Maximum bonus they have also said, so that from the employer point of view, employees can't harass me that pay me more, pay me more. Okay, we'll see. So first is payment of bonus. So what is the object of this act? The object of this particular part is to pay the bonus to the employees, timely payment of bonus, and to decide who is eligible to get the bonus. Okay, objective of this act is to, so that the employees receive minimum bonus. Okay, and they have also set maximum limit of the bonus, so that employees don't start harassing employers. Now imagine one employee, he came, joined yesterday. Okay, let's say an employee came and he joined on, let's say 31st March he came and joined. On 1st April, he's asking that, where is my bonus? So I'll tell him, come here, I'll give you a bonus, turn around. You want 1 lakh or 2 lakhs? Okay, so that basically, is everyone eligible for bonus? Obviously not. We will see who are eligible for bonus is a person if he has worked at least 30 days in an accounting year. So very simple. Eligibility for bonus. If you have worked for less than 30 days, you are not eligible to bonus under the act. Common sense. So that too they have said how much time have to work? Minimum 30 days. Obviously the bonus amount is calculated on how much time you worked also, but if less than 30 days you are not eligible only. Minimum 30 days of work. Then you are eligible to get the bonus. Clear till here? Section 26 done. Now they say how much is the minimum and the maximum bonus. Very simple, very easy. Section 26 subsection 1 subsection 2. Mark it is important. Minimum bonus. For example, you think from an employee point of view, and that to a blue collar employee. Okay, many industries they realize that employees they are working very hard, they're going home late, they're working overtime, and in India also work conditions, most of the time their face is like this. Yes or no? Let's say their employee is like this, working really hard. If I want to put a smile on his face, even a small bonus I give him, can he become like this? Yes. So this is your minimum bonus concept. That give them minimum bonus and finish it off. It has been a practice for many years to give it to blue collar people. Give it. So it is how much? 8.33% of the wages I give them as minimum bonus. This is even if I don't have profits in the current year, I have to remove from my reserves and give them. We will see what happens later, but minimum bonus has to be given irrespective whether you have profit or no. Concept clear? How much percent have to give? 8.33%, or they've given you a very weird figure, or 100, whichever is higher. So how much they given? 8.33 or 100, whichever is higher, which is obviously going to be 8.33 is going to be higher. That's the minimum bonus. Maximum bonus, imagine if the company has made, now this was when company didn't have profits, still we are telling them give them profit, give them minimum wage. Now imagine if the company has made a huge profit. Can I say that these employees will be looking for a very high big, this is the that coming what do you call? Slur. And that bonus is going to come, we are going to have party, etc. So imagine the company made a huge profit, then the government has said, listen, you don't ask too much, employer is business has risk, and don't harass the employer. So to keep it balanced, they have also set the maximum bonus. Irrespective, even if I have a massive profit, employees I can give them maximum bonus in a year is how much? 20% of wages. Is the minimum maximum bonus concept clear? Done. If I don't have profits, I have to still pay how much? 8.33. And if I have a huge profit, I have to pay only capped till 20% of wages. Concept clear? Yes. Now, one exemption has been given to new establishment. If for the first 5 years, any new company, for the first 5 years, they don't have profits, then bonus need not be paid. They will only pay in the accounting year in which they have got profits. Again, in the first 5 accounting year, where the employer sells the goods or manufactures the goods, bonus shall be paid only in the accounting year in which profit has been derived. So for new establishments, can I say that there is a benefit given? For first 5 years, do they have to mandatorily give minimum bonus if no profit? No. They will give bonus only if profitable. Concept clear? After that, the bonus provisions will start. So exemption given to the companies. Now, imagine there was an employee who was short tempered, and we told him to wait for 1 hour more. And the day we told him it was his birthday, but we said it's a deadline. And further, his family was calling and had prepared had also booked a hall to celebrate. But we told him it's a deadline, you have to stay in the company and work. And that guy was short tempered. What do you think an employee will do? So what he did is he took the employer and on the laptop he banged him. He took the boss's head, banged it on the laptop, and he said, "It's my birthday, all this, etc." And that is it. Do you think he's entitled for bonus? On the date of the bonus, when he goes, they say, "We are very sorry. Bonus is given for people who have helped the organization and not those who have done violent behavior." Or if a person was found, like imagine they found an employee was there, he was going out, they stopped him, security check. From the pocket they came to know he has taken the mouse of the company, he has taken the pen of the company, okay, some all different things he has put it in his pocket and he was leaving. Will that person be entitled to this? He was selling the data of the company. Allowed or not allowed? So he will also, any person who's done fraud, riots, theft, misappropriation, or any conviction for sexual misconduct. So all these people will be disqualified from bonus. It's important, they can ask you. Concept clear? Done. Now, there is one provision which again is important that you need to know. Section number 36. Set on and set off of allocable surplus. Clear? Now understand that it talks about minimum wage and maximum wage and the provisions of set on and set off. Clear? This is important. And then essentially the topic gets done. So first thing when we see allocable surplus. Yes, allocable surplus is the amount that we have to distribute as bonus, right? Now, if the allocable surplus, what is allocable surplus? Surplus, which we have to allocate as bonus to the employees. If the allocable surplus is less, pay attention. If the allocable surplus, first you pay attention, later you write after you understood. If the allocable surplus is less than the minimum wage that we have to give. So let's say if the allocable surplus was 100 and when we do 8.33% of the wages, it came up to 120. So can I say that the company has a shortage? Shortage is of how much? 20 rupees. So this 20 rupees, we have a shortage. Profits are only not there, but we have to give the minimum wages. So employer will remove from his own pocket, from his past year's profit and give. Was he required to give? Ideally, he didn't have profits, but because of the law, he had to give. So this 20 rupees will be carried forward. I pay them today. But this, I have this deficit. This was the deficit that was there. Deficit will be carried forward. I paid them, but I will remember that I didn't have profit and I removed from my pocket. It will be carried forward to be set off from next year's allocable surplus. Then it looks fair. Understand? I didn't have profit. but I still paid. Next year when I have profit, I will deduct that amount from my profit. Then it looks fair, na? I had, let's say next year I had a lot of profit, but I will say that I had paid you when I didn't require. Now I will deduct that. I will set it off. Then balance amount I'll distribute as dividend. It becomes fair. So allocable surplus is less than the minimum wages. The person will have to give the minimum wages. However, he doesn't have to worry because next year when he has the profit, he will be able to, that deficit amount which was there, he will be carried forward in next year and will set off from his surplus next year. Now see this other category, allocable surplus and maximum bonus. Maximum bonus. Now imagine if the maximum bonus allocable surplus is 100 and allocable surplus is 120. Pay attention. If the allocable surplus is greater than the maximum bonus, so can I give them? Allocable surplus is the amount that I have to distribute as bonus. But I tell them, oh my god, cannot, I want to give you, but I can't. Law has set the maximum bonus to 20%. And when I do 20%, it is coming to 100. So that 20 rupees I can't give you. So the employee will be sad or no? I tell, don't be sad. This excess which was there, excess surplus, you don't have to worry. This excess will be carried forward. Today I can't give you, but I will carry forward it next year to be set on into the allocable surplus and I will pay you. Understand? Today I couldn't give you. That profit I will add it up next year. So next year when it is possible, I will give it to you. Allocable surplus will be increased. And if it doesn't touch the maximum bonus, you will obviously get that 20 extra. So that becomes set on, means it has been added into the next year. Today I can't pay you, next year I'll pay you, na, finish. Here I paid you extra, so I will take a set off. Okay, all this can be carried forward till max 4 years. All of this can be carried forward for max 4 years, after which it will lapse. Within 4 years, if this adjustment is there, it is fine, otherwise it will lapse. Clear till here? Means what? I have to see. Now you tell me, if I didn't have profits, but still I had to pay, do I have to worry? No, because whatever deficit was there, which I didn't have, I will next, and I had to pay. So that I will adjust it from the profits. If I had lot of profit but I couldn't give due to maximum bonus being hit, so that excess which is there, I will give it to you next year. Understood? So that is what has been given. That is it. So set on is for excess allocable surplus, yes or no? Where the allocable surplus exceeds the maximum bonus, then that excess will be carried forward to be set on into the succeeding accounting years. That will be there. In set off what happens? Deficiency was there. So deficiency means what? The allocable surplus is less than the minimum bonus, but that deficiency will be carried forward to be set off against the surplus of the next accounting year. So I paid it now, so I'll set it off against my next surplus. Concept clear? That is it. Okay. Then I told you these are all common points, that advisory boards will be there about wages both at central and state level. They will advise with respect to what to do. Payment of dues, claims and audit, very simple, that they talk that if there is any dispute, if any claim is there, etc., they can apply to the labor code and they will decide how much wages is to be paid and to whom. Whose responsibility ideally will be there to pay the wages? Employer, etc. Okay. Then we see your inspector. Inspector will have the same provisions. He has a right to inspect the books. Same one common answer you learn from any labor, all the things, and you can write it. Offenses by companies will be the same. Okay. Composition, same. Offenses, compounding, and same points will be given. With this, we have completed the entire law on wages. Thank you. Clear till here? Yes or no? Write in the chat box if it's audible and clear. Okay. Now we'll do the last labor code and then we are done for the day. What is it? Law on security, right? Code of security. Let's see. So we'll take a 5-minute break and then we will restart. Hi. So now we'll begin with your next topic, okay, which is your code. Okay. Let me know in the chat box if I'm audible and visible. We'll start and complete this chapter as well. Just trying to figure. Okay. So let me know in the chat box so we can quickly start with the code on social security. Okay. Great. Can we start? Yes or no? Just in the chat box. Can I have GTG in the chat box? Great. Chalo, let's begin with the code on social security. Right. Hi, so we'll be starting with the topic called as code on social security. Now, any topic or answer comes, first we write the introduction beautifully. The introduction is basically what is this code about? The code on social security. So, it is a law relating to social security and labor welfare. Sir, what do you mean by the term social security? Now, if you go to see in countries like Canada, they provide a lot of social security, social nets like maybe unemployment allowance, some kind of benefits. In India also, we provide some kinds of social security. We provide basically social security in the form of provident fund, pensions, your particular life insurances. Then we provide some kind of employment. Whenever there's an employment injury, we get employee compensations. This is what the chapter is about. Okay. So there were 9 social security legislations earlier. They all have been clubbed into one single code, that is this social security code. The 9 acts that were there, these are the 9 laws. The core, the most important social security codes were your PF, Provident Fund. Nowadays, if you see anyone is employed, when they get their salary, some amount is cut as PF. Later, as a retirement benefit, it is given to them. Next, if you go to see, insurance is taken for the employees, so that if there is any injury, etc., they can get a insurance done, and the insurance company will pay the employees. Third is employee compensation. This employee compensation is where there is a disablement, okay, while working into the company, then again compensation can be claimed. Plus gratuity is also another kind of social security. Now it is not necessary that in on a particular company all these laws are applicable. They are called as scheduled laws. Each of these particular acts apply to specific industries. So it is possible that for me, Insurance Act and PF is only applicable to my organization. So each industry sector attracts certain labor laws. It has to be seen from case to case basis. So these are the main labor codes that are there that we will be covering. And this objective of this code is to cover not only the organized sector who are covered with your particular PF, etc., but even the unorganized sectors like your gig workers. Gig workers are your delivery partners who are outside the formal employer employee relationship. So, for them also, some kind of benefits have been given, and social securities like life cover, health insurance is extended even to the unorganized sector. Now, when we look at the legislative framework, we will see how many sections are there and how many chapters are there. Now, if you see this, first is you have total of 164 sections, and there are a total of 14 chapters. From this, let's see what is the main. Now, I told you which all codes are there. So, your Provident Fund Act is a chapter 3. That is, I'm telling the important chapters. Your insurance, your gratuity, most important, most important not only now, even practically. And if you see, women have been granted tremendous benefits under the maternity laws in India, that we will see. And that if any lady is there working in any company, they would definitely want to know what rights do they have during their pregnancy, and during the maternity benefits given by the company to them. That is important. Then also your employee compensation in case of disablement or death is covered here. And then we see for gig workers, this also I feel is very very important, because the aim of this code is not only to cover the organized but even the unorganized sector. And this is what I feel is also important from exam point of view as well, because it is new. It was never there in the earlier law, and now we have concepts to you know cover and give social security benefits even to gig workers, platform workers who are working on the railway platform, even they are covered. Okay, rest all common points like offenses, penalties, all of this is common. Let's begin with the chapter. Now the first interesting code that we will be doing is directly your PF, Provident Fund. So this is the first major law that had been subsumed under this code. The first, Provident Fund. Now what are the provisions? If you know that you're working, you get a PF, your employee has a Provident Fund account. If he's shifting his work to another employee, okay, it's not necessarily you might work under one employee for your lifetime, right? So your Provident Fund account also gets transferred from employer to employer. And once you, then how you can remove the money from the Provident Fund, and mostly people use it for their benefit, for whenever they need help in life, they can go and take the Provident Fund, recover it. So even knowing how to get it and who to apply to get this Provident Fund, how to you could say withdraw your Provident Fund will be there. So the Employees Provident Fund is actually a financial security to the employees. Okay, and contribution into this fund is given by both employee and employer, which we will see, and various benefits are given. This is administered today. Today, if I want to see who is the regulator, administrator of this Provident Fund schemes, it is a EPFO. What is the full form? Employee Provident Fund Organization. Very important. They become your EPFO, become the main administrator of these schemes, supervisor of these schemes. Now, under this particular thing, under this code, that is the Provident Fund code, there are 3 schemes prepared by the government. Most important is your section number 15. Mark it as important. It's a central law. So central government has made this, giving a social security scheme to the employees. How many schemes I told you are there? Very important. The entire chapter is circulated, or we could say is covered under these 3 schemes. Is surrounded. Okay, under the 3 schemes, and it's very very interesting to understand what happens to your PF. First is called as your, first I will read through, then I will explain you, then when I'm doing the explanation you can write it with me. So 3 schemes. First is called as your Provident Fund scheme, second is called as your pension scheme, and third is called as your employees deposit linked scheme. So any question comes, you will say that EPFO is the administrator of these schemes, and there are total of 3 schemes under the Provident Fund. The first one is Provident Fund, where both the employer and the employee will contribute a certain percentage of their wages. Employer will also remove from his own pocket, and he will deduct certain amount from the employee. Second, pension scheme. Now obviously, when is pension used? At the early stage of your career or the retirement? So these are obviously retirement benefits. When superannuation, when you take a superannuation means compulsory retirement. So that time you will get. at retiring, whenever you have a total disablement, when a person has become a widow, so the compensation will go to his widow. Sometimes if you see that in pension schemes, not only the employee is covered, but after his death, his wife will get the compensation, maybe 50% of what he used to get. Children pension, orphans, all this can be used. Okay. And the third one is your life insurance scheme. Obviously, when a person dies, the nominees will get the life insurance, the life cover, whatever is there. Clear? Three schemes. I have not yet explained how these three schemes work. First, section 15 is clear that there are three schemes. Which are the three schemes? PF. Then the second one is your EPS, that is pension scheme, and the third one is your insurance scheme. Now the fund. You have three funds. Same for those three schemes, three funds are made. Provident fund, pension fund and insurance fund. Concept clear? Yes. Till now I haven't told you how the scheme is working. I'm just telling you that there are three funds and it is administered by whom? EPFO. Okay, there are trustees. It is a trust. So there are trustees appointed by the central government who will manage these three schemes. Now comes to the important contribution part. Pay attention how it works. Okay, how it works. This is the distribution of that scheme, and now you will understand how these three schemes work. Very, very important. Okay, I want you to make it with me. First understand, then make. So let's see. The contributions. Contributions. Very important. This is the heart of the chapter. First is contribution. If you go to read in PF when we are done, who will remove money? Both employer and the employee. Both will remove the money. How much? So ideally 12%. How much? 12%. In different cases it could be prescribed 10%, but standard and most common is 12%. So if any of you or your family members or your brothers sisters are working, you will see that their PF is cut around 10 to 12%. Clear? Now this contribution of 12%, entirely 12% of the employee goes, let's see, of the 12% contribution is there. Employee's entire contribution of 12% goes to PF, but the employer's contribution is split. 8.33 goes to pension fund and employer's contribution of 3.67% goes to provident fund. Means employee's entire money goes where? To provident fund, PF. This goes entirely to provident fund, 12%. Whereas for the, let's say, it goes in provident fund. Clear? But for the employer, 12% doesn't directly go into PF. Some amount goes here and some amount goes to PF. So let's say if the wages is 100, from employee I will deduct 12%, and employer from his own pocket he will remove 12%. Employees, whatever deductions I do from his salary will go directly into PF account. Whereas employers, we'll see for employers, to pension scheme, from this 12%, 8.33% goes to pension scheme and the balance amount. So when you do 12 minus 8.33 is how much? 3.67% will go into PF fund. Have you understood? So from the contribution of the employer is split into pension and provident, and employee goes direct. In addition to this, there is one deposit linked insurance also. For insurance, the employer has to remove, only the employer will remove additional 1% of wages. So can I say that now in PF how much money will come? 15.67. In pension fund how much will come? 8.33%. And in insurance how much will come? Additional, means the employer is actually removing 13% and giving. Concept clear? This is how the three funds will get their funding. Let's see if we have understood. This is the core of the chapter. Okay, that employees contribution goes 12% directly into provident fund, whatever 12, 10, whatever, it goes directly. Employers contribution 8.33% goes to provident fund, and the balance amount goes to this goes to pension fund, and 3.67 goes to provident fund. And employers contribution up to 1% goes to insurance. This is additional. Is the distribution and the three schemes absolutely clear? If it is done, we are done with the part. Now let's see. Now just one important thing, just for the simple practically, imagine if the employee, for every employee a particular universal number is made, employee universal number is made, so that we can locate his how much PF is eligible to him. So if I'm working now, employees, I'll get an employee card in which my identification, how you have an Aadhaar card, PAN card which is dedicated and identified by you, for you only, like that for a employee card you will get. So I will come to know that this number, this is how much PF is visible. Now in the PF, initially who puts the money? I will put, and who else will put? Employer. I change the employer. Now don't you think I have to put it in my account? In my account I have to switch my employer. So I require NOC from the other guy, from the earlier employer. So they have said when an employee changes the employment, the accumulated balance in the provident fund will be transferred to the new employment account in the accordance with the scheme, so that the scheme benefits continue. Clear till here? That will be done. Now we are done with this part. So can I say it is a nice retirement benefit, because in this PF he is getting insurance and he is getting pension, etc. So during the time of retirement, this is what we expect the employee to be doing. Very rarely you will find this, because they're not showing that he also has a family who has control of these funds. Okay, so now going to the next thing is your chapter 4, employee state insurance. Very simple insurance word you need to focus, highlight, and concept is clear. Do you know what is insurance? Common sense. Whenever there is a SIM, you can get this insurance claim. SIM is sickness, injury, maternity. In case of sickness, injury, or maternity, this insurance amounts can be claimed. So what literally happens here, the employer removes an insurance for the employee. Whenever he is sick, insurance company will pay. Whenever he has an injury, insurance company will pay. Whenever there is a maternity, the insurance company will pay. Is this concept clear? So for this, to get an insurance, regular premium amount someone has to pay. Who will pay? Employer. Concept clear? Done. Now obviously you will see overlapping benefits given in maternity, in employment injury also. So not all acts applicable to one industry. It is possible that only one act is applicable. For some other act will be applicable. Clear? So accordingly you will get any one benefit only from one particular place. So let's see, chapter 4, employment state insurance schemes. is a social insurance system, okay, which provides a protection to the employees who are risk at sickness, maternity and injury. Okay, now this entire money of taking the insurance, paying the premium, disbursement of the amount to the employee is all managed as we had above as EPFO. Here we have Employee State Insurance Corporation, called as ESIC. Concept clear? Yes. Now, so a fund will be made and it is administered by whom? All contribution paid. Now this government will tell how much contribution employer will give, how much contribution employee will give. That all the state government will tell. They will pay it and it will all go into the fund. The fund is ESI fund. What fund it is called? Employee State Insurance Fund. And it will be managed and administered by what? ESI Corporation. Clear till here? Done. Let's move ahead. Now, section 26. Very simple, very logical, and no rocket science. Where the money of this fund will be used. From the name itself, insurance is there. So when you can claim your insurance, when there is a sickness, maternity, injury, you require medical treatment, there is a hospitalization, okay, whenever any kind of improvement of health, welfare is needed, rehabilitation of disabled person is there, money can be used. Yes or no? Plus, from this fund, money can also be used to pay the employees of the ESI. ESI workers will also be there in the fund. From this fund, we will use to pay the government employees also. Now, first is, can I choose my favorite employees and insure them, or all employees have to be insured? All. So every employee working in an establishment shall be insured, and that person will be called as, that employee will be called as insured person. Contributions will be made by whom? Section 29 states that the contribution will be made by employer and employee, and they have told that it will be told by the respective law. So these codes have given you, and they have left the states governments to make the internal rules, which will give you exact percentages, etc., because it can differ from state to state also, right? So here in this code, what we are doing is that both contribution can be taken, and these contribution will be taken and paid in this to this corporation. I will go into that fund. Concept clear? What are the benefits? Again, we can write similar benefits under the ESI. SIM, right? Sickness, maternity, disablement. In case of death, benefits will be given to dependents. Medical benefit, and in case if there is a death, what the employer will do? Imagine the person who has worked for you for so many years has unfortunately died. So we will pay them funeral and expenses so that he can be buried also. Okay, next. That's it. And then they have a concept of employment injury. Very, very simple. To claim a employment insurance, injury should also be related to employment. Imagine if the employee sitting at home was playing PlayStation, and somehow he fell down and got injured, and he comes and he claims in the company that I was playing and my child whatever threw that controller on my face, and now I am need some benefits. Will the government give you? They will not. Ideally, there has to be employment injury. Now, sir, what do you mean by employment injury? Employment injury means that it should be an injury which is arising in the course or out of the course of employment. In or out of means what? Either it should be a direct link, or as per notional extension of time and place. Notional extension of time and place, even if the person is not, for example, when I say direct link means what? He should be working in the factory. During the factory hours, he will get injured. If he gets injury, we will pay him. But what if he was commuting from home to office and injury is there? Should he get paid? Yes. From office to home, he should get paid. He is going to the client's office, he should get paid. But in a contract, even if he is working overtime and he gets injured, so that is called as we extend the time and place of the injury also. We are ready to extend the time and place to give them the compensation, as long as there is a nexus connection between the injury and the employment, right? So going to a client's place and getting injured gives you the compensation as well. For occupational diseases, can he get compensation? Obviously yes. Occupational disease is a disease which is related to that occupation. It could be the person could get this occupational disease even post employment. He can come and claim this compensation. Okay. Now the thing is medical board. Now imagine one employee, he looks hale and hearty. He looks what? Hale and hearty, big smile on his face, and he is saying, give me, I am injured, pay me compensation, and trying to claim insurance. Can we pay him? We tell him, pick up that thing, he picked it up. We said, move your arm like this, he moved it. We said, can you do sit ups? He did the sit up. So we asked him that, why you want compensation? So he said, I am injured. I said, what injury you have? He said, I can't hear. I said, is that true? He said, yes. Now the point is, there is a dispute. He is saying, no, I am injured. So the thing is, we will have there in this particular ESI, we also have a medical board where there will be medical practitioners who will do an investigation whether he can hear or no. So when he looked here, so then they will do some test, prepare a report, and then tell whether there was a loss and how grave that loss was. Accordingly, the compensation will be given. Common sense. So medical board is important or no? How will you know he is injured and how much he is injured? Someone can fake an injury also. Okay. So questions relating to permanent disablement and loss of earning capacity are examined by the medical board. Okay, the medical board determines whether an accident resulted in permanent disablement, right? Second, if there is a loss of earning capacity. Then third is whether how long that assessment will go on just to examine him. That's it. And then you have a ESI court also made in case if anybody is wanting to contest the report prepared, they can go in ESI court. Now medical benefits can be given obviously for, it's an insurance, right? So any kind of mediclaim, hospitalization, any clinical test, home visit, wherever required, all that will be paid. I told you ESI court is also there. I told you there are two main bodies in employee state insurance corporations. One is the medical board to examine the extent of the injury and whether it was connected with employment. And second is the ESI court to hear disputes between employer employee and to hear disputes with respect with the quantum of the amount given, because so many times insurance companies reject claims, gives very little claims, so that also is heard by the officers. And this is a proper court to hear and adjudicate disputes with respect to how much liability is there, what is the employee status, how much wages is there, entitlement benefits, okay, and we'll hear the disputes between the employer and employee. An appeal from this court will go to High Court. Section 52 says if you are unhappy with the decision of ESIC, you can go to the High Court. Then we are done with the chapter. Then we do your next chapter, which is called as gratuity. Okay, gratuity comes from the English word to thank, thankfulness. So if an employee has worked for multiple years in our company, and on the last day, let's say he's worked for over 20 years. There are employees who work for one company throughout 20 years, and let's say on the last day of his work, when he has retired, we all cut a cake and we all tell him thank you so much, click a picture, and we tell him you can leave, we'll miss you a lot. Will he go? He will look, he'll wait for something. What is that? Some amount of retirement benefit called as gratuity. Gratuity is paid at the time of retirement or resignation. Okay, that is there. So this is given as a benefit, retirement benefit for a reward for the long and continuous service to the company. Okay, first is how many years he has to work to get gratuity. Imagine an employee who has just joined the company, is leaving the company and asking for gratuity. He's like, where is my thankfulness? Work, I told you how many months you have worked. He said, I have completed 1 month in this company. Now I'm leaving it. Where is my gratuity? So we will remove our left or right shoe. Okay, so very simple. We will tell them you're not entitled. You have to work for 5 years continuously with the company. 5 years of continuous service. Market is important. To claim gratuity, you have to work 5 years continuously with the company. Then gratuity becomes payable. Okay. And when is gratuity payable? Very simple. In D square R square. In D square, let's see whether it fits in D square R square. So when we will thank him, superannuation. What does superannuation means? Compulsory retirement which has hit the age. So generally 58 years, and then they tell you have to leave. So then we'll pay him retire. Second is retirement or resignation. So either retirement or compulsory retirement, voluntary retirement. Then D square, death or disablement. Okay. So let's say the employee was working and then for some employment injury he got and he got disabled. So what we will give him? Gratuity. Then next is when he has completed his term of employment. If there is a certain term given and he's completed the term, that is it. So what is D square R square? Death, disablement, retirement and resignation. Retirement includes compulsory retirement and voluntary retirement. And one more, they are saying that D doctor and a term is over. Okay, fixed term employment and that term is over. Term is over. So that is it. Now tell me one thing from here. When do you think that 5-year continuous work we will not count? Like there is an exception to the 5-year requirement. Think and tell me for D square. For which? For D square. Imagine if he joined the company and there was a machinery that exploded and he was working in that machine and obviously it exploded, so he is no more. Now will we tell his family that he has not worked for 5 years? We said in the very first day you have disappeared him. So 5 years you did allow him only. 4 years and 364 day you kill him, and then you say 5 years. So the law says we don't want to get into that. If there is a death, directly take 5 years. We will not. It's too wrong to ask. If let's say he is disabled, we will not ask. if his fixed term employment is over. So imagine I only appoint him for 4 years and 364 days for his work. The contract is for this. So once that is over, we tell him, "Arey, sorry, 5 years is not over. 1 day was left. How sad. Now we don't have to give you this thing." So they say no. All these cases, it wasn't his fault. He was nicely working, and 5 years could not be completed. In all these cases, he will get the employment. Clear till here? Very simple. Done. Now the thing is, in case of death, how will we pay him his gratuity? Where we will go to give him? To his house and give it to his family members, nominees. Understood? Legal as minor. Now the calculation, how much gratuity will we give him? Imagine an employee who worked for 20 years with the company, we pay him 200 rupees and we say thank you so much, keep the change. Is it okay? Obviously there is inhuman and very vindictive, or I could say insane to believe this. How much is the gratuity we will give him? We'll tell him, come here, sit, let's calculate your gratuity. 15 days wages for every completed year. So 15 days wages into the number of years of service. Right? So if I come to know his 15 days salary was 20,000 and he's worked for 10 years. So how much we'll pay him? 2 lakh rupees. Very simple. No rocket science. That is there, okay? However, the government can set a maximum limit also to give the gratuity, okay? Because common sense, it is possible that someone might be high earners in your particular salaries. For them, if you go to calculate, it might just go really high. So the government can, and normally they also keep a upper limit that government will notify from time to time. Forfeiture of gratuity. Very, very simple. Same, I had given an example that there is one short-tempered employee. He has beaten up 3 employees. And now when it is time to give gratuity, he's coming forward, and that too he has punched 2-3 people and come ahead of the line. Can we give him the gratuity? So we imagine that short-tempered, is already angry, already punched people, and now you have to break the news to him. That gratuity cannot be paid to you. So in all these cases, gratuity will be forfeited. When? If he has damaged the employer or his property, if he has done some violent acts or moral turpitude. In such case, you can forfeit the gratuity partially or completely. Okay. Now, when we see the next thing is he can nominate someone in case of his death who will get the particular thing. Okay. Then these are the key provisions. Disputes will go to the court. I think the core provisions we are done. That is it, and we are done. Now we come to the most important part, is your chapter 6, which is your maternity benefit. Extremely crazily important is your maternity benefit. So it's a very big boon to women, okay? And you will see that how much benefits government has given to you. First, before I start, do you know how much benefits, how much paid leaves do women get when they're working, and as maternity benefits? So let's see, approximately 6 months of paid leaves you get. Okay, so let's see the benefits given for women under maternity benefit. They can ask you, kindly state the provision that women have during maternity benefit during pregnancy. So during pregnancy, women get financial support, health protection, and job security. They cannot be removed when they are pregnant. Okay, so during pregnancy, childbirth, etc. So let's see the section 59, prohibition of employment during certain period. Now imagine they are telling that when a baby is born, they are extremely dependent on mothers. So law is saying that employers are prohibited to employ women if they have just given delivery. Even women are prohibited from going to job when they have just delivered. Okay, so it ensures complete rest immediately after childbirth. This is for the benefit not only of the mother but also the child. So that is section 59. Very simple. Employer is prohibited to employ women during 6 weeks immediately following delivery. 6 weeks is how much? 1.5 month approximately. Yeah. So moment a child is born, 1.5 month is nothing. Baby is 1.5 month. So you obviously employer cannot employ, nor the women can also work. Within how much time period? Same. During 6 weeks immediately following delivery. Go and the baby's health is most important here. Section 59 subsection 3 says during RDS means hard. No hard work during pregnancy. I mean work which are strenuous, like standing for long hours, etc. So a pregnant woman makes a request to the employer, then the employer cannot give any kind of physically demanding work, long standing hours work which interferes with their pregnancy, fetus, etc. Okay, this protection, like for how long can she say that I don't want any work of this? So the protection for strenuous work as stated above is during 1 month before the 6 weeks during the delivery date. Now I made a summary where it summarizes everything, but I'll just tell you this. Can you calculate how many weeks will come here? 1 month is how much? 4 weeks and 6 weeks. So protection from strenuous work applies during 1 month before the 6 weeks before the expected date of delivery. So if this is the expected date of delivery, 1 month before the 6 weeks. In short, they could have said 10 weeks earlier before the expected date of delivery. So you can write there 10 weeks before delivery. No person can demand a pregnant lady to work into strenuous work. Let's see. So if I have to summarize this part, during early pregnancy she can work, there is no problem at all. Last stage of pregnancy, that is 10 weeks before the expected date of delivery, she can demand that I don't want any RDS or strenuous work. And delivery to 6 weeks after delivery, complete prohibition. After delivery, 6 weeks, that was 1.5 month, complete prohibition. Nobody can employ a woman who have just delivered. Now directly I'll come to the part where she will get, and this the salary will be of 3 months. The average salary, so when we have to pay her money, also paid leaves, so the average wage earned during the last 3 calendar months will be taken as a daily wage. For example, if I have to give her paid leaves, so what is the salary? Average of the last 3 months. So I'll come to know average of the last, if she has got 20,000, 25,000 and 30,000. So I know that the average is 25,000. That becomes the average pay, and the calculation will be done keeping 25,000 in mind. Now let's directly come to the benefits given. Here is all the benefits given to the women. Market is super important. This is what I have summarized. So I told you that how much benefit is given. So up till now, understand the language, okay? Women with less than 2 surviving children. Less than 2 means 1. Less than 2 means what? 1. So 1 surviving child you have, that means your second child you will get the benefit. For your second child, because first child, there is only one surviving child, and the other one you're pregnant now. So you are entitled to 26 weeks of paid leaves. 26 weeks is how much? 6.5 months approximately. So this much amount of paid leaves you are eligible. And out of this 26 weeks, maximum leaves that I can take is up to 8 weeks before delivery. Means 8, you think that in the late stage of pregnancy I will need, not me, if you think that a lady would require at the later stage of pregnancy she would require leaves, or early stage? Later only, na? So before 8 months, up to 8 weeks before delivery, she can take only 8 weeks. So if delivery is here, up to 8 weeks before delivery, she can take certain leaves. Before that they are not giving, because later she will definitely need. So leaves allowed before delivery. Up to 8 weeks leaves are allowed before delivery. And if you have 2 or more surviving children, then you get 12 weeks benefit. And leaves allowed before delivery is 6 weeks. Up to 6 weeks of leaves are allowed before delivery. Adoption of child below, so this is the adoption of child below 3 months. If someone has adopted a child, then they can take a maximum maternity leave they can take is 12 weeks. Okay. Commissioning mother, that is surrogacy is there. Okay, so then she can also take for 12 weeks. Okay, this is the part. So now if you go to see now pay attention to this, okay, the calculation. A woman can get 26 weeks of maternity leave. Out of this 26 weeks, maximum before delivery, how much she can take? 8 weeks of leaves. Out of this 26 weeks, a maximum of 8 weeks can be taken before delivery. That means law is saying that after delivery you take. That is when you will literally need it. Now my question is very simple. Now this is not in the law, just for a practical advice to women. When ideally they should take the leaves? See, if this is the expected date, and this is what normally women do, okay, expected date of delivery. Ideally the doctor tells you that we are expecting the child to be born on X date. So now before the expected date of delivery, how much she has total, how many leaves? Total leave she has is of 26 weeks. Now I'm telling you how she can strategically plan. Law says that before delivery and after delivery. Before delivery she can take maximum how many leaves? 8 weeks. Rest all she can take post delivery. Now ideally one should not take the leaves before the delivery. All of that only when it is, suddenly when they have to go, or they are capable. If they are planning the leaves, then ideally they should plan all of them mostly later. Like they have to emergency leave for going, if they are feeling like that in the 9 month they will go, that is fine. Most they should try to use their 26 weeks here. So some people, that is the extreme, but still some people prefer to work till the very last date. Suddenly they will feel that they are expecting the child, so then they will rush to the hospital. Till that they were working only. So that why I'm saying this, normally people prefer this, because they get maximum time to be with the child. Here till as much as the lady can bear it, she would be there working, so that she gets this 26 weeks or maybe 25 weeks, 24 weeks with the baby. So the planning is up till them. Law has also restricted to that 8 weeks, all from this 26, maximum 8 weeks can be taken before you stay with the baby. Logic clear? That is there. Then if you go to see, all this we've done, even she can request the employer that if possible to allow work from home. Then comes one point. Now when the payment of the maternity benefit is to be given, right? payment of maternity benefit. So very simple. If she is leaving, if she's already told her before delivery I am going, so then maternity benefit should be paid in advance only. But if she's saying that I want it after delivery, okay, I'm going to use my leaves after delivery, so then whenever she gives the proof of delivery, then within 48 hours the employer will have to make the payment. So proof of delivery, what you'll do, you'll send a pic of the baby with a cartoon here. You know, nowadays they don't like to show the face, so they'll put a flower here. Or they might give a letter or whatever, a birth certificate, and claim the amount. Okay, so that is there, simple. Medical bonus additionally can be given of 3,500 rupees if the employer doesn't have his own hospital post-natal care. Now obviously most of the organization are not going to have their own hospital, so if they don't have, then additionally they have to give 3,500. Okay, leaves for miscarriage, also termination. So section 25 also talks about leaves for miscarriage, so even that is covered in paid leaves, that is also given. Then till the child, now this is also very nice for mothers who have mothers who have just delivered. They are getting 2 nursing breaks during working hours. Okay, so even till the child attains 15 months, normally you can understand that big companies, they might have the children area caretaker, so the mother takes the child, okay, and they can nurse the child, that is feed the child. You get 2 breaks separately. Okay, then even a creche facility is to be given wherever 50 or more employees are there. Creche is basically daycare facility in the organization where you can take care of the baby. Babies can play, etc. So the summary major benefits, if we see, the biggest benefit you should know is 26 weeks. Out of this 26 weeks, maximum leave she can take is 8 weeks before delivery. For miscarriage also they get tubectomy, they get 2 weeks. Tubectomy is basically in villages or sometime when to limit the children, they do a special surgery called as tubectomy. They tie the tube so that they don't have further children. Additional leaves are there, nursing breaks is there, medical bonuses there, and creche facilities there. So these are the benefits given to the women during their maternity benefit. So you can write the conclusion that about all this, for not only for health protection, job security, child care, benefits have been given. The next and the last chapter which is there is your employee compensation. Very simple, very few specific things only we need to know. Employee compensation is given whenever there is a employment injury. Employment injury. Now, employment injury could lead to 2 things. One is disablement, okay, total disablement or partial disablement, and the other thing is, what could be worse? Death. So, or death. So when all this is happening, like say there is a disablement or a death, then what the employer will do? Give compensation, called as employees compensation. Simple. Now how much compensation to give is what is the law about. Okay, this is very simple. And they are saying that, imagine if there is compensation is to be given, the employer also should have not to give. So they say we normally get a insurance done to cover this. So this provisions can apply to some few establishments. So you write the introduction that the chapter 7 talks for compensation to employees in case of employment injury, disablement or death. Even occupational diseases is covered. So the object of the act is to give the financial relief and medical relief support to the employees. Clear? Now imagine if there is a, let's say there is a particular death in the organization or a bodily injury. So what will you do? You will prepare a report and inform the authorities that we came and we found him dead. Okay. Then comes to the compensation. Employer's liability for compensation. Simple part. Who is liable? Let's say the employee was negligent, and because of it the employee got injury. But who will pay compensation? Employer. Okay. For any personal injury caused to the employee, if it is by accident or by occupational disease, he will be there. Employer will not be liable. Imagine if there was a kind of an explosion, employee was sitting on a machine on which he was not supposed to sit, because of which it got heated up and it exploded. And let's say there was an injury on, he was sitting, so there was an injury. But this guy had fallen. Some people came to help. Slowly, they made him walk, and now he was able to walk in the next 3 hours. Is compensation liable? Is the employer liable to pay him compensation? No, because if the injury does not result into disablement for more than 3 days, let's say he was for 2 hours he couldn't walk properly, was limping for 2 hours, compensation given? No. He should have acted for how much time? 3 days. More than 3 days, then he is directly eligible. Now, coming to how much compensation is to be given, that is among the most important part of the chapter. That is your section number 76. Amount of compensation, most important part. In case of death, we will pay him 50% of his wages into the relevant factor. Relevant factor is like his age, salary, some other factors that we will see, that government will tell you. So 50% of the wages or a notified amount, whichever is more. So they will notify an amount, so whichever is more. However, if there is a permanent total disablement, so we will pay him 60% of his salary or notified amount, whichever is more. We are paying more in case of death or in disablement. See here, in death we are giving him 50% of the wages. But in disablement, don't you think there will be medical expenses more? So that is why they are giving 60% or the notified amount, whichever is higher. In case of partial disablement, okay, compensation will be given if there is a loss of earning capacity, etc. It will be given to him as well. But this, when there is now all this was permanent disablement. When there was a temporary disablement, okay, which after few days he became fine. So in that case, till he is not fine, we will pay him. Let's say this guy, I to give you the example that he was sitting and then it exploded and he fell down on the ground, and now he is limping for 4 days. So employer will be like, I have to pay him. He is limping for, let's say, 20 days, 1 month, 2 months. So we have to keep paying him till he is limping. It's not permanent. He will be fine. Okay, he's taking all those things and he's walking. Like, okay, fine. Till when I have to give him? So here we wait for 15 days. So every 15 days we will pay him 25% of the wages. Understood? So it's called as half monthly payment will be given, equivalent to 25% of his wages. So 25% of his wages is 10,000 rupees. Every 15 days we will pay him 10,000 rupees. The day he starts walking, now imagine we were just looking from the corner, he was walking properly. Moment he is coming in front of us, he is limping. So we will stop the payments. Okay. Let's say unfortunately he exploded, hit the ceiling and died. Very sad. We'll pay him funeral expenses of 15,000 rupees. Okay. All sensitive topics. Okay. So that is it, and I think this is the core of the chapter. Yeah. Now we come to the next chapter, which is your social security for unorganized workers, gig workers, platform workers. Very, very important. Okay, it's a new concept, so therefore the chances of it coming in the exam is very high. And here the government has said that for all these unorganized gig workers, platform workers, gig workers are those who are not coming under traditional employer-employee relationship. So for them, we will give them benefits. Now, what benefits we will give and what schemes we will prepare? Very simple. We will take, the government will prepare a scheme. In that scheme, we will say for these unorganized sectors, we will also give them life insurance, health insurance, old age protection, education, etc. They will prepare various schemes by state governments to give them PF. In all these benefits we saw, we are just extending it to these unorganized people also. Education schemes for children, skill upgradation, funeral expenses, old age homes, all these benefits will be given. That's it. But one helpline center is also given. Helpline number will be provided that all these unorganized sectors, if they have any issue, want any kind of assistance, want to get updated about their scheme and their rights, they can apply to the helpline number that will be made by the government. Now, very important one thing is schemes for gig workers and platform workers. Now, no doubt the same provisions that the government will prepare schemes of life, health, old age protection, creche facilities, all of that we saw above. There is one specific thing that they are saying, contribution to aggregators. Aggregators are basically a platforms that connect the businesses with the customers, like your Uber, your Swiggy, Zomato. They don't directly sell, they just have a aggregating platform which connects to people. So if I look at a aggregating platform like Zomato doesn't have its own food, it connects. Okay, even you look at those shadi.com, what do? They connect. Okay, so those are Swiggy, those delivery partners, etc. Amazon, those delivery partners. So they are all called as aggregators, food delivery, economic logistic providers, travel, media content platforms. So all of those who are there, who aggregate for their people, these benefits are made. They are saying that these aggregators have to contribute. Now imagine if someone is working for Amazon, Swiggy, Zepto, who are having all these gig workers, these companies have to contribute some amount. Now how much is important? Now pay attention to this, that the aggregators are required to contribute towards social security schemes. This we know, done. The contribution should be not less than 1% and not more than 2% of turnover. That means the contribution to the social security scheme is how much? Should be 1 to 2%. Okay, of what? Of their annual turnover. So imagine Amazon, what must be their annual turnover? 1 to 2%, the government will tell you exactly that much they have to contribute to the social security scheme. The government has put an upper limit also, that such contribution shall be subject to a cap of, so all this, whatever it is subject to a cap, that is 5% of the amount paid to gig and platform workers. So I will take my annual turnover. Imagine my annual turnover is 100 crores. So 1% is 1 crore. But I will say that I have paid to gig workers 10 lakh rupees. So I will say I have very few gig workers. I have only 1 lakh gig workers. So then I will just say 1 lakh, the 5% of 1 lakh, that is the maximum amount. Though my turnover might be more. So ideally they are saying 1% and 2% subject to 5% of the total amount that I have paid to the gig workers. That will be the maximum contribution that aggregator has to do to social security schemes. Okay. that is it. And I think the next part about offenses, compounding, provisions are exactly the same. With this, we have completed the entire chapter. Thank you. हो गया. I'm not on YouTube. Okay. So that is it, guys. We've completed the entire chapter and the entire marathon. So do like the video and share it with your friends as well. Okay, if you're watching it later, do put in the comment section that any words that you want to say. Thank you so much. All the very best. Do join the WhatsApp group. Take care, guys. Bye.